My name is Matt Nosenchuk, and I work as Senior Counselor to the Assistant Attorney General for the Civil Rights Division at the U.S. Department of Justice. That's a lot of energy for 8 a.m. That's great. Let's keep it up. It's really wonderful to be here at the Burroughs Community School, which is such a beautiful school, for this White House LGBT Conference on Families. I speak for all of my colleagues and partners in the administration when I say that we are especially pleased to be holding this conference here today in conjunction with the Family Equality Council's Midwest Conference, which is so appropriately titled Family Matters. Why, you might be asking, is a Department of Justice official kicking off a White House conference? Well, we are one administration, and those of us across the agencies and at 1600 Pennsylvania Avenue collaborate closely across a wide range of issues. But in addition, I'm opening this conference today because Gautam Raghavan, the White House liaison to the lesbian, gay, bisexual, and transgender community, had a last-minute unavoidable conflict. So he asked me and Mike Martinez from the U.S. Department of Agriculture, who you'll meet this morning, to step in and cover, kind of emceeing the logistics for this conference. And we're both really honored to do this, and Gautam is very sorry to miss today's conference, and he sends all of you his regards and looks forward to following up with all of you after the conference. We have a terrific program for you today, and before we get things started, I want to give you some background on today's event as well as a general sense of what to expect. So in the 3 years since President Obama took office, his administration has taken significant steps to ensure safety, justice, equality, and dignity for the LGBT community. From passing the Matthew Shepard and James Byrd Hate Crimes Prevention Act to repealing Don't Ask, Don't Tell, we've seen this president honor his commitment to our community time and again. And as many of you know, we have also benefited from a number of other incredibly important actions that make a difference in the day-to-day lives of LGBT people, like policies to prohibit discrimination in housing and rules and regulations to address the needs of LGBT families, including, but not limited to, the needs of LGBT federal employees and their partners and children. You'll hear more about what the administration is doing for LGBT families this morning. But as you all know, the hard work doesn't end with a memo or an announcement or the launch of a new program. In fact, that's usually where the hard work starts. Implementation is key, education and training are critical, and your feedback is invaluable. So that's why we're here today, as part of a series of White House LGBT conferences that are being held across the country. We kicked off this series 2 months ago in Philadelphia with a conference on LGBT health, followed by one on housing and homelessness in Detroit, safe schools and communities in Dallas and Fort Worth, HIV/AIDS in Atlanta, and then on May 7th, the series will wrap up in Miami for a conference on LGBT aging. The goal of these conferences is to empower advocates and organizations and interested members of the public with information, resources, and opportunities that the Obama administration has to offer. And we want to hear from you. Tell us about what's working, what's not working, and what we could do better. We want to know about the challenges and obstacles you face. And if you are successful in your work, we want to hear about the innovation and best practices. And chances are, others in the room will want to hear about them as well. So at this morning's conference, you'll have the chance to hear from senior government officials and from nationally recognized advocates working to address the needs and concerns of LGBT families. I'm especially pleased to be joined here today by two of my Justice Department colleagues, who you'll hear from shortly, Stuart Dellery, the Acting Assistant Attorney General for the Civil Division, who not only holds one of the most important roles in the Justice Department, but along with his partner is the father of 2 children. And we're joined here by Greg Brooker, the Civil Chief of the U.S. Attorney's Office here in Minneapolis, who will talk about the Justice Department's efforts to address harassment and bullying in Anoka-Hennepin, Minnesota, the state's largest school district. But now you've heard enough from me, so we have quite a morning lined up for you. Before we get started, I want to acknowledge, however, the community leaders and the families who helped make today's conference possible. To all of you, thank you for the courage and commitment to equality that you demonstrate every day. Your leadership sets an example for all of us in Washington and throughout the country. And in terms of housekeeping, I just want to note that today's session is open to the press. And for photographers, please feel free to take photos of what's happening up here on the stage, but we ask that you respect the privacy of the audience members and not take photographs of them. Finally, we encourage you to tell people about your experience today through social media and hope that you will tweet along using hashtag #WHLGBT and the Twitter handles listed on the agenda. At the Safe Schools and Communities Conference in Texas that I helped to plan with Gautam, we had a constant stream of tweeting, and it was very cool, and it was great to go back and look at it after the conference and read what people had to say. So last but not least, the White House would like to thank the Burroughs Community School for hosting this conference. And I want to give a special thanks to the Family Equality Council and its Executive Director, Jennifer Chrysler, and its Policy Director, Emily Heck McGowan, and the other staff for inviting us to piggyback onto their conference today. So now, without further ado, I'd like to introduce to you the leader of the Family Equality Council, Jennifer Chrysler.
Good morning. How are you all? All right. A special welcome to our youngest members of the audience. It's one of the things I love about Family Equality Councils. I see some babies smattered around here. I'm cooking one of my own on the way, so I know what that's going to be like in a few months. First of all, I want to thank you all for being here on this really historic occasion where we are welcoming all of you to the White House Conference on LGBT Families. I think Deb Talon's in the room and Laura Smidzik's in the room, and I'm going to bet that we have some other folks in the room who have been long involved in the family community here in Minnesota, and I'll just talk louder so until it comes back on. And I bet you when they started our conference here in the Midwest, they didn't imagine that there would be a day where our own president and our White House and that administration would be here listening and learning and hearing our concerns. So it really is a historic day for all of us. And we're joined by a crop of very talented and influential policymakers from our nation's capital who are working every day to find ways to make life better for our community, and most importantly for our families and for our children, which I know all of you in this room care so deeply about. And Family Equality Council is really proud to be able to partner with the White House and this administration to bring this conference right here to the Twin Cities. So it's a great day. We're also going to be welcoming our very own Senator Al Franken to the stage this morning, which we're really excited about. Someone who's been a real leader on our issues and champion for our community. Minnesota is home to thousands of parents who are lesbian, gay, bisexual, and transgender, who want the same things for our children as all parents do. We want respect and protection and a really bright future for our kids. And we know that our community of moms and dads are raising their children to love their country, to stand up for their friends, treat others the way they would like to be treated, and to tell the truth. But the truth is that society still discriminates against our parents and our children based on our love for one another. So together, you and Family Equality Council have been working in partnership with the President and his administration in making significant change for our families. Change for the better, change that improves the quality of living, and change that addresses not only our needs as LGBT people, but our needs as families struggling with the economy, with the rising cost of college, with the collapse of a housing market, and the need to access quality and affordable health care. All things that as families matter as much to the LGBT community as it does to anybody raising kids in this country. Some of you may know that 3 years ago I had the privilege and honor of standing with our then newly elected president in the Oval Office as he signed a presidential memorandum extending some benefits to our federal employees. It was a really amazing occasion, as I'm sure you can all imagine, but it was most importantly a very important first step in making sure that our government was more accessible and more responsive to our community. Now, when I entered the room, I of course took the opportunity to show him pictures of Tim and Tom, my twin sons, Because I don't know what parent, when they had the opportunity to talk for 2 minutes to the leader of the free world, wouldn't start with the pictures of their kids. But that's what I do, so. But I also thanked him for taking that step and for moving the ball forward. And I told him that we had much more work to do together, and that Family Equality Council would be there with him every step of the way, providing not only inspiration, but the individual stories of how our families are impacted that could really help him make the kind of change that he envisioned for our country. So 3 years later, we have a lot to be proud of. You know, Matt talked about two of the biggest, the Hate Crimes Act and the repeal of Don't Ask, Don't Tell, but there have been so many, a long list of accomplishments, both big and small, tangible and symbolic, that have made a real difference in the lives of so many parents who are lesbian, gay, bisexual, and transgender. Whether it's clarifying Family Medical Leave Act for our families, whether it's making sure that we can visit our loved ones in the hospital in a time of need, their refusal to defend the so-called Defense of Marriage Act, the President's recent endorsement of the Student Non-Discrimination Act and the Safe Schools Improvement Act. I mean, the list just goes on and on and on. And we have been really proud to be there with this administration every step of the way, helping them see and helping them do what we know is right for our families. But I want to say one other thing that I think has been really important about the last 3 years, because it's not only the change that has been made, but it is really a president and an administration that has opened its doors in really unprecedented ways to our community, to make sure that our needs and our concerns are heard, that good ideas are actually genuinely considered as solutions to our problems, and that we as a community can be part of the solution that they are working so hard to enact. Family Equality Council has been able to engage in conversations at every level with this administration and to be able to advocate for and on behalf of the 2 million children who are being raised by 1 million LGBT families in this country. Today's conference is really just a continuation of what has been 3 years of that good partnership, that good dialogue. And it's really an opportunity for all of you, instead of me going and having those conversations or staff from Family Equality Council going and having those conversations, it's really your chance to have those conversations, for you to engage, for you to ask questions, and for you to help educate those that are working really hard and really diligently to make our lives better. So it is a real joy to be here with you this morning for the first portion of our really exciting day. And I thank you all for getting up early and being here. And I am now going to turn it over to Emily Heck McGowan, our Director of Public Policy at Family Equality Council, who's going to introduce our first keynote speaker. So thank you all.
Good morning. I have the distinct honor this morning of introducing Acting Assistant Attorney General for the U.S. Department of Justice's Civil Division, Stuart F. Dellery. Stuart joined DOJ in January of 2009 as Chief of Staff and Counselor to the Deputy Attorney General and later served as Associate Deputy Attorney General prior to his current position. Before joining DOJ, he was partner in the Washington, D.C. law firm of WilmerHale, and he has long been an advocate for the LGBT community. I had the good fortune of working with him several years ago when I was a staff attorney, a little baby staff attorney, with Service Members Legal Defense Network. We had filed a lawsuit challenging the constitutionality of Don't Ask, Don't Tell on behalf of 11 men and women who had been discharged from the military for being gay or lesbian. And Stuart agreed to serve as our lead pro bono attorney on that case. It didn't take me long to discover that Stuart was a brilliant lawyer and a passionate advocate for LGBT equality, and I learned a great deal from him. In his current capacity, Stuart oversees the largest litigating division in the Department of Justice. The Civil Division represents the United States in legal challenges to congressional statutes, administration policies, and federal agency actions, and also defends the President, cabinet officers, and other federal employees in lawsuits filed against them. Just a couple of weeks ago, Stuart represented the federal government in front of the First Circuit Court of Appeals in the case Gill v. the Office of Personnel Management, which is a case challenging the constitutionality of the so-called Defense of Marriage Act. Stewart argued the government's position that the Defense of Marriage Act is unconstitutional and should be struck down. And if any of you had the good fortune of listening to that argument via live stream, it was quite brilliant and a historic moment in the fight for marriage equality in this country. Ladies and gentlemen, please help me in welcoming Acting Assistant Attorney General Stewart Dellery.
Good morning. And thank you, Emily, for that very warm introduction, and thanks to Jennifer and the rest of Family Equality Council, not just for your partnership in organizing this great event today, but for all the hard work you do every day to ensure that all families are recognized and protected and respected and celebrated. And it's a pleasure to join Family Equality Council and my colleagues from across the administration, and especially all the families here today, as we collaborate to address some of the challenges faced by families headed by gay and lesbian parents, or that include LGBT individuals. Were I not here with you this morning, I would be at a similar conference back at home with the rest of my family because my partner is one of the organizers there. But I've promised to be back in time, or try to at least, in time for our Little League game this afternoon. And I really hope that I make it. I'm sure all of the families here can relate to this. We're used to juggling sports and other events on the weekends, although usually not in different cities. Now, as Emily mentioned, I'm the Acting Assistant Attorney General for the Civil Division, which is the largest litigating component in the department. With over 1,000 lawyers and 1,400 employees, we are, as Emily said, essentially the federal government's law firm. Our clients include the President, the Cabinet, federal agencies, and Congress, and our docket involves nearly every aspect of what the government does. In my first 6 weeks in the job, I've dealt with national security issues, immigration, healthcare fraud, mortgage and other financial fraud, claims arising out of the damage from Hurricane Katrina, and that's just to name a few areas. But while you may not know us by name, you may be familiar with some of the ways the division and the rest of the administration is working to nurture families of every kind. As has been said, over the past 3 years, the President and federal agencies throughout the government have taken crucial steps to support LGBT individuals and their families. For example, same-sex partners of federal employees now have access to benefits like sick leave, life insurance, and moving expenses. All hospitals that receive federal funds, like Medicare or Medicaid, must allow all patients to receive visits from their families and loved ones, including same-sex partners. And Customs and Border Patrol recently announced that families in one household, including domestic partners and their children, can make a single joint declaration when they return from overseas travel. You'll hear more about what our other agencies are doing over the course of the day, but I wanted to take a few minutes this morning to talk about some of the things the Department of Justice is doing that directly affect LGBT families. First, as Emily mentioned, the department is no longer defending equal protection challenges to Section 3 of the Defense of Marriage Act. Section 3 defines the terms marriage and spouse for purposes of federal law to exclude same-sex couples, even if they're legally married under state law. This means that these couples are not entitled to the more than 1,000 federal benefits, rights, and obligations that are given to all other married people. These range from Social Security benefits to immigration rights to health care coverage for spouses of federal employees, the types of things that really matter in the daily lives of families. In February of last year, the President and the Attorney General reached two important conclusions. First, they concluded that laws that make distinctions based on sexual orientation, similar to laws that make distinctions based on gender or race, should get what's called heightened constitutional scrutiny, meaning a close review. And second, they concluded that as applied to same-sex couples who are legally married under state law, Section 3 of DOMA violates the Constitution's guarantee of equal protection. Because they had determined that Section 3 is unconstitutional, the President and the Attorney General directed the Department to stop defending it against these claims in litigation. So what prompted this decision? 2 lawsuits were filed in November 2010. The plaintiffs there were same-sex couples who were legally married in their states and who wanted federal benefits for their spouses. They brought equal protection challenges in parts of the country where the courts had not yet decided how closely laws that target gay and lesbian people should be scrutinized. And this had not been the case in DOMA cases we had been litigating up to this time. In considering what the answer to that question should be, the President and the Attorney General considered the same factors that courts do when evaluating whether laws that target a particular group get close constitutional review. These factors are designed to identify distinctions between people that are generally not appropriate bases for government to consider in making policy. Factors like the long and deep history of discrimination that gay and lesbian people have faced and continue to face to this day, and the reality that, while sexual orientation is not visible exactly, it would be unfair for a law to require LGBT individuals to hide their true selves in order to avoid discrimination, and the fact that sexual orientation says nothing about an individual's ability to contribute productively to society. The President emphasized this last point in the context of the military when he signed the repeal of Don't Ask, Don't Tell into law. He said, quote, "Valor and sacrifice are no more limited by sexual orientation than they are by race or by gender or by religion or by creed. At every turn, every crossroads in our past, we know gay Americans fought just as hard, gave just as much to protect this nation and the ideals for which it stands." Now, considering all these factors, the President and the Attorney General concluded that laws that treat people differently based on sexual orientation, like laws that make classifications based on gender or race, are inherently suspect and therefore must meet a higher burden to be found valid. And since that time, the Department of Justice has articulated this position in briefs filed in courts around the country. There is no question that DOMA targets same-sex couples and treats people differently based on their sexual orientation, that it was motivated in significant part by prejudice towards moral disapproval of, and stereotype-based thinking about gay and lesbian people and their intimate and family relationships. Indeed, it is exactly the kind of law that so-called heightened scrutiny is designed to address. To meet this test, a law must not only advance an important state interest, but there must also be a sufficiently tight fit between what the law claims to do and what it actually does. And, as the Department has argued, DOMA's Section 3 fails on both counts. Let me give you an example. One justification that Congress gave for Section 3 back in 1996 was that it would promote procreation and responsible child rearing. But of course, there's no evidence that same-sex couples are anything other than fully capable of responsible parenting and child rearing, and in fact, the opposite is true. It won't surprise anyone here today that many leading medical, psychological, and social welfare organizations have concluded after numerous studies that children raised by gay and lesbian parents are as likely to be well-adjusted as children raised by heterosexual parents. And as today's gathering makes clear, hundreds of thousands of children are being raised in this country by gay and lesbian parents. By denying the children of legally married same-sex couples the benefits that Congress created to foster stable home lives for children, Section 3 of DOMA, in fact, undermines the security of the very children it claims to protect. The Department recognizes that ultimately the courts will have the final say on whether Section 3 is unconstitutional. To allow that process to play out in an orderly fashion, the President has directed the executive branch to continue enforcing Section 3, even as we encourage courts to conclude it is not a valid law. So far, in our first case on Section 3's constitutionality since the President's announcement, a district court agreed with the Department found that heightened scrutiny applied to classifications based on sexual orientation, and struck down DOMA as a result. This is the first time that any federal court has made such a ruling based on heightened scrutiny, and there will be more rulings to come. Meanwhile, as DOMA was a law passed by Congress, that body can also pass legislation to repeal DOMA, and the President has endorsed legislation that would do just that, the Respect for Marriage Act. Now, beyond DOMA, the Department of Justice has committed itself to combating hate crimes, bullying, and harassment. That commitment is based on a simple truth, which the Attorney General recently affirmed at another White House LGBT conference. Quote, "No one deserves to be bullied, harassed, or victimized because of who they are, how they worship, or who they love." According to the FBI, there are more than 1,000 hate crimes against LGBT people every year. And these numbers increased, according to the statistics, from 2005 to 2010. The Department's Civil Rights Division is vigorously enforcing the landmark Matthew Shepard and James Byrd Jr. Hate Crimes Prevention Act, which provides federal prosecutors with new resources and authorities to seek justice on behalf of all those who are victimized on the basis of their race, ethnicity, religion, national origin, and, for the first time ever, their sexual orientation, gender identity, or disability. Since its enactment in 2009, the Department's Civil Rights Division has trained thousands of law enforcement officers and community stakeholders on the law to ensure that this powerful tool is put to good use, to protect individuals from violence and intimidation, and to achieve justice for the victims of these despicable acts. Already, these efforts have yielded significant results. Just this month, the department secured an indictment alleging that 2 men in Harlan County, Kentucky, kidnapped and assaulted a man because he was gay, the very first federal hate crime charge based on sexual orientation. If convicted, the defendants face a maximum penalty of up to life in prison. Now, hate crimes prosecutions are essential, but they alone are not enough. That's why the department is working in close cooperation with our state and local partners and through our Defending Childhood initiative to help prevent these crimes before they occur and to encourage greater reporting when they do. It's why we've joined forces with other federal agencies like the Department of Education to intervene in communities and school systems where discrimination, bullying, and harassment have been reported. And it's why we're reaching out to our nation's young people through educational programs that teach tolerance and understanding. As all of these examples make clear, the department is working hard to protect and support LGBT families. And I want to end by sharing one more important initiative on this front, our broad-reaching efforts to protect consumers. Now, this work isn't really particular to the LGBT community, but I mention it out of recognition that LGBT families are really just families. And families spend most of their day worrying about basic issues like mortgages and tuition and health. So within the department, we have significantly increased our civil and criminal enforcement of federal consumer protection laws, and we've expanded our focus to include new areas that impact families on a daily basis. These range from our efforts to negotiate the recent $25 billion settlement between the states and the nation's biggest mortgage lenders over foreclosure abuses, to defending the president's landmark health care legislation, the Affordable Care Act, which aims to ensure that the act aims to ensure that no child goes without health care. They include our work to prosecute mortgage fraud and foreclosure rescue scams that prey on families at their most vulnerable points. We also want to make sure that the food and medicine you buy is safe. So we're prosecuting manufacturers who market their drugs for uses not approved as safe by the FDA, with as much vigor as we prosecute those who sell tainted baby food or supplements. And we're working closely with the Consumer Product Safety Commission to make sure that the toys you buy for your kids won't harm them. And finally, because every family would love an hour in peace for dinner, We're actively involved in pursuing companies that engage in robocalling. So while these efforts may not always make headlines, they do make a difference. And while a lot of progress has been made, much remains for us to do. But by reaffirming our commitment and continuing this important dialogue, we can work to promote and protect all of our families. Thank you all very much.
Thank you, Stuart, for those incredibly inspiring remarks. They really give a flavor for all that the administration and the Justice Department are doing to further the equality of LGBT families. So now we're going to transition to our first panel of the day, which is entitled Recognizing LGBT Families. So if we could get our panelists to come up to the stage, and Jennifer Chrysler is going to be moderating. And I'm going to take my seat because I'm on the panel.
So I'll just start here, and then I'm going to move in a second. So let me just tell you a little bit about how this panel and the next panel are going to go, so you all know what to expect. And it feels very like teacher-like to be in front of the auditorium. I keep waiting for like an assembly or a song or something to go on. So this is the audience participation portion of the program here. So what's going to happen is I'm going to take a minute to introduce our panelists. They are going to each spend a few minutes talking about, in particular, their area of expertise within the federal government and some of the things that they have been doing that help recognize our families. I'm going to pose a few questions for our panelists and let them have a good dialogue back and forth. And then really, the last portion of the panel will be open to all of you. So as you can see, there are index cards coming around, some of our snazzy Family Equality Council pens, which you're welcome to put into your pockets and take with you. And what you can do is write your questions as our panelists are talking and pass them to the end, and folks will come around and collect them from you, and then I'll bring them up here and ask questions of our panelists from all of you so that your questions could get answered. So that's how it's going to work from a logistics perspective. Before I introduce our panelists, I do just want to take a minute. State Senator Scott Dibble has joined us, and I just want to take a minute to recognize him and his leadership. Well known, well loved, and we thank him especially for introducing the Safe Schools bill that we were a part of helping draft and which we'll be working on here in Minnesota. So without further ado, I'm delighted to introduce our first panelists to you all. Starting way down on my left, we have Brian Cook, who is the Director of Media Relations and is with the Centers for Medicare and Medicaid Services within the U.S. Department of Health and Human Services. And then we have Nancy LePink, who is the Deputy Wage and Hour Administrator within the U.S. Department of Labor. We have Elaine Kaplan, who is the General Counsel in the U.S. Office of Personnel Management. And, of course, Matt, who we've all come to know already, who is the Senior Counselor at the U.S. Department of Justice. So I'm going to take my seat. I'll try to figure out microphones as we bounce back and forth. But without further ado, our panelists for this first session.
So why don't I start? I'm Brian Cook with the Department of Health and Human Services. Just really quick, want to thank Jennifer and Emily and all the really, really wonderful people at the Family Equality Council. I've had the privilege to work with them in the past, and they're just an extraordinary, extraordinary organization. At HHS, I don't want to spend too much time talking at you, but just want to go over some of the important things that we've done to recognize and protect the health and well-being of LGBT families. The President and the Department have taken direct action on some important steps that make a real difference in the lives of families. I think the first and most visible effort that we've taken is in the area of hospital visitation. I think prior to 2010, there was a scenario that was all too common. You'd find out that a loved one, that your partner had a medical emergency. They'd fallen ill very, very quickly or had been in an accident. You'd rush to the hospital. And you would find out, you would be told that it doesn't matter how many years that you had spent with this person. It doesn't matter that you have a home together. It doesn't matter that you have children together. That we do not recognize you as a family. And that you're not allowed to see your loved one, your husband, your wife, at a time when they need you the most, at one of the most critical moments. And so what we do at HHS, we have rules and regulations that govern any hospital that gets paid by Medicare or Medicaid. And at the direction of President Obama, HHS said to every hospital that does business with Medicare or Medicaid, if you're going to get paid by Medicare or Medicaid, you have to have policies in place that say that LGBT families, that same-sex partners are allowed to see their loved ones in the hospital. And so in 2010, we took that step. In 2011, we clarified that in addition, that folks who are in the hospital can say that they want their partners to make decisions for them. That if they are incapacitated or unable to make decisions, that they are able to say who makes those decisions for them. Another way of recognizing LGBT families in the hospital setting. The good news is that these rules and regulations also apply to nursing homes as well as hospitals. There's been a significant number of steps that we've taken in terms of grants. We've given millions and millions of dollars to create programs that support LGBT health in communities. The Administration on Children, Youth, and Families, who I believe you're hearing from the administrator later today, they've given grants to centers that would address barriers to permanency in foster care for LGBT children, which is one of the biggest problems in foster care. We've created the first ever resource center for older LGBT Americans, so that families, caregivers of older LGBT Americans have all of the resources at their disposal. So we've taken many, many direct actions that help the health and well-being of LGBT Americans. One of the most really, really historic efforts that's going to help, that is already helping LGBT Americans, but also all Americans, is the passage of the Affordable Care Act. And so that is that's a really, really, really fundamental change in how we provide health care in this country. It, for the first time, says that all Americans have access to quality, affordable health care. And among other aspects, it touches on a lot of the circumstances that LGBT families know far too well. For instance, if you don't have health care and you can't get it through your spouse because their employer says, well, we don't consider you a family. Starting in 2014, we're going to be opening up marketplaces where individuals can they can comparison shop for health insurance, and the insurance companies have to compete with each other to lower prices. And the government will be providing taxpayer subsidies so that that coverage is more affordable. Right now on healthcare.gov, you can go search for health insurance right now, and you can specifically filter and say, I want to buy a policy that will also cover a same-sex partner. And we just did that, I think, a couple of months ago, and that's a really, really historic step. An individual with a pre-existing condition starting in 2014. Prior to the Affordable Care Act, insurance companies could say, we don't need to give you coverage. Starting in 2014, they can't deny you coverage. They can't say that they can't charge you more for having a pre-existing condition. They have to offer you coverage. They can't discriminate against you. And a lot of Americans with greater health care needs, prior to the Affordable Care Act, they may have faced arbitrary limits on what coverage they could have. They faced caps on how many benefits they could get a year, or the danger that if they got sick, the insurance company could say, okay, we're going back and we're rescinding your policy. We're dropping you from coverage. Right now, that is no longer the case. That is illegal. So the President and the Department of Health and Human Services, we've taken many, many steps already directly that are helping LGBT families and recognizing LGBT families. As we're implementing the Affordable Care Act, we are taking more important steps that are going to really protect and secure the health and well-being of LGBT families. So, thanks.
Good morning, I'm Elaine Kaplan, and I'm the General Counsel at the Office of Personnel Management. Very happy to be here today with the Family Equality Council for this summit. And I want to talk a little bit about the work that we've done at the Office of Personnel Management to make the federal workplace friendly to all families, including LGBT families. This is an issue that is near and dear to me, not only because I work at OPM under the leadership of John Berry, who is the highest-ranking openly gay appointee of the President, and by the way, the named defendant in some of the cases that Stuart was describing earlier, but also because I myself have raised two daughters with my partner of 27 years, and so we've experienced firsthand, and also back some time ago, sort of the sense of frustration about the things large and small that LGBT families have to face, from government forms that required us to cross out the word father and write in parent or mother to, and then there was always a discussion between us, who is mother to and who is mother one, to so-called, and fortunately we're running into that problem less and less frequently now, to so-called family health insurance plans that cover my daughters but not their other mother. But I can tell you that, to coin a phrase, things have gotten better since my oldest daughter, who turns 21 next month, came to us back in 1992. Back then, we always had a lot of splaining to do whenever we started the kids in a preschool or took one of them to a new doctor or arrived together for a parent-teacher conference. Things are changing. They're due in large respect, I think, to efforts of the organizations like the Family Equality Council. And in the last 3 years, a lot of progress has been made by the Obama administration, which I've been very proud to be a part of. You know, we've always understood that some of the most significant reforms, such as the repeal of DOMA, would require legislative action. Nonetheless, we also know that we can effect important, albeit incremental change through administrative action. So to that end, and Jennifer had mentioned this earlier, just 5 months into his tenure, the President issued a memorandum directing the Office of Personnel Management to survey federal agencies, determine which benefits that are available to opposite-sex married couples we could lawfully extend to same-sex domestic partners, and then report back to him. And in 2010, we reported back to the President with a whole list of, good benefits that we could provide to LGBT families, and he directed that federal agencies extend the benefits we identified. So the benefits extended, or soon to be extended, include relocation and other benefits for partners of foreign service officers and other federal employees stationed overseas, relocation and federal travel benefits for same-sex domestic partners of federal employees, eligibility for long-term care insurance programs for same-sex domestic partners, use of sick leave to care for domestic partners and children, child care subsidies and daycare center privileges for federal employees and for the children of their same-sex partners, the presumption of something called an insurable interest for same-sex partners that allows them to receive some form of survivor annuity, non-competitive appointment rights for the partners of federal employees returning from overseas appointments. Pretty early on, we issued a statement on USA Jobs, which those of you who've looked for federal jobs may be familiar with. It's the portal into the federal employment. We issued a statement prohibiting discrimination based on gender identity in federal employment, and guidance issued to all federal agencies regarding fair treatment of transgender federal employees in the workplace. So to be sure, for now at least, some of the most important benefits of federal employment, such as the right to coverage under the Federal Employee Health Benefits Program or eligibility for a full survivor annuity, are still not available because of DOMA and other statutory obstacles. The President supports the repeal of DOMA and, as Stuart mentioned, has stopped defending its constitutionality in federal court. The administration has also supported passage of something called the Domestic Partners Benefits and Obligations Act, which would extend full health and retirement benefits to the same-sex domestic partners of federal employees. And we continue to look wherever we can for other steps that we can take administratively to create a level playing field for LGBT families. And this is not only an issue of fundamental fairness, but it also makes good business sense. As many of you may know, and as Director Berry had testified in supporting the Domestic Partners Benefits and Obligation Act, the majority of Fortune 500 companies have employment policies that are family-friendly for our families. In fact, in addition to that, what's interesting, and certainly this is true of my daughter's generation, young people, whether gay or straight, consider the provision of such benefits to be an important thing that they look at when they're considering employers, because they view it as just sort of an issue, again, of fundamental fairness. Again, much more work needs to be done, but we're very much on the right track, and we look forward to working with you guys and with the Family Equality Council to be able to do more to create progressive and fair policies and benefits that can be extended to all employees' families, including those of our LGBT employees. Thank you.
Collectively, these laws cover most private, state, and local government employment. They protect over 135 million workers and more than 7.3 million establishments throughout the country. In 2009, when the Secretary of Labor, Hilda Solis, walked through the doors of the Department of Labor, she flung them open again and welcomed back in, after 8 long years, workers and their families and the organizations that advocate on their behalf. And she took the time to meet with them, to listen to their concerns and ideas, and then she turned around to her leadership team and said, work with these people and get the job done. I've had the privilege of working in the Department of Labor under the leadership of Secretary Solis for the last 3 years, and she has demonstrated her commitment to the LGBT community, to not just opening the doors, but actually bringing into her leadership team individuals that come from this community who are passionate about the issues that confront them, particularly that confront their families. Department of Labor, dignity, respect, equality often doesn't come in one single act. It comes in many small acts along the way. The Wage and Hour Division, in its role of administering and enforcing the Family Medical Leave Act, took a step in the spring of 2010 to make clear that the definition of son and daughter under the Family Medical Leave Act covered all families, made clear that persons who care for children, who stand in loco parentis, have rights under the Act to provide necessary care, to nurture those children with the protections that the Family Medical Leave Act provides. The department also, in this past winter, we've engaged in a survey of the use by individuals, workers across the country of family medical leave. We've made some important changes to that survey to make sure that it's inclusive of all families in this country. Those changes, again, they seem small when you read them, but they make a significant difference in actual application to be certain that information about LGBT families are included. One of the questions that was changed in the survey was, instead of saying how many of your own children live in the household, it now says how many children under 18 years old are in your care. The employee survey also for the first time gives individuals the option to identify sexual orientation as well as family relationship. Such questions are designed to enable us to get more accurate information about the makeup of American families today, including same-sex households. We've also added questions designed to capture information about challenges and barriers to using family medical leave, to identify potential discrimination in accessing that leave. Respondents can now let us know if they did not take leave because the person they wanted to care for was not considered a covered family member under the FMLA, or that they were worried about revealing their familial relationships. This information will be critical to developing future policy, to developing future regulations, to developing and establishing priorities for the administration as it relates to our administration and enforcement of this act. I'm also pleased today to have out front on a table the first edition of the Department of Labor's the Wage and Hour Division's Guide for Employees on the Use of FMLA, Family Medical Leave. It's a first-time effort to actually provide guidance to workers as opposed to compliance assistance for employers. It makes absolutely clear the coverage of this leave for persons who are standing in loco parentis, makes clear that that coverage applies to same-sex parents and the care of their children. And so I encourage you to take a copy. It's actually quite good. Could have probably used it a few years ago myself when navigating the Family Medical Leave Act, which is really a two-step dance and places a lot of responsibilities on workers, and it's critical that you understand your role in ensuring those rights for your family. I thank again the opportunity to be here today. Welcome your questions. It's a good day in Minnesota. Thanks.
Thank you very much. So as I was preparing for this panel, I thought to myself, what is there left for me to say? As you just heard wonderful remarks from Stuart Dellery about what the Justice Department is doing for LGBT families in the courts by arguing that Section 3 of the Defense of Marriage Act should be struck down. And on the next panel, you're going to hear from my Justice Department colleague, Greg Brooker, who is a key member of the team that achieved the historic settlement with the Anoka Hennepin School District to address harassment and bullying. Including harassment and bullying of LGBT students who fail to conform to gender stereotypes. And my co-panelists today, as well as Stuart, have spoken about the many benefits that have been extended to LGBT federal employees and their families under our existing authorities, and our administration's efforts to obtain new ones by passing the Student Non-Discrimination Act or having DOMA repealed. So one thing I can say is, like Elaine and like Stuart, I'm also an LGBT parent, and as I learned last night at the Family Equality Council reception, I'm part of the demographic that actually started this organization. A gay dad who was married to a woman and wanted to continue to be the best and most engaged parent that he could after coming out. And in fact, one of the first LGBT family-related activities I did with my son after I came out was to take him to Family Week in Provincetown. In fact, I think I remember meeting Jennifer standing under the Pilgrim Monument. My son was 8 at the time, so now he's 14, and like Stuart, if I wasn't here, I would be driving around, Montgomery County or Prince George's County to some AAU basketball tournament today, or a baseball practice. So what I do also want to say about the administration is that there have been a lot of momentous actions and achievements, but one thing that's perhaps worth thinking about for a moment are not the big ways that the administration has brought about real gains for LGBT families, but the smaller ones, the more mundane ones. So I have one story to tell. Back in 2009, shortly after my boss, Assistant Attorney General for Civil Rights Tom Perez, was confirmed to become the head of the Civil Rights Division, he was asked to testify in the U.S. Senate before the Senate Help Committee on the Employment Non-Discrimination Act. And I remember one exchange in particular that Assistant Attorney General Perez had with Minnesota's Senator Al Franken. So at one point, Senator Franken remarked on the generational differences that exist on kids' attitudes towards homosexuality. And Senator Franken speculated that for his kids, he thought that for his kids, whether someone are gay or lesbian is about as interesting to them, and will be for that generation about as interesting to them, as whether or not someone is left-handed. To which my boss, Tom Perez, responded, "Well, I'm ambidextrous." Which I still haven't quite figured out what he meant by that, but it's one of my favorite moments from my time working in the Obama administration. But the point that Senator Franken was making is kind of the point I want to make here today. When we talk about LGBT families in the administration, there are a lot of big steps, like determining that we wouldn't defend DOMA. But there are a lot of steps and advances that derive much of their significance by virtue of the fact that they're really not such a big deal at all. For all the legislative policy proposals and pronouncements, there's recognition of LGBT families that happens each and every day in this administration. We have a president and administration that's been willing to take a stand in the courts on behalf of LGBT federal employees who have been denied benefits under DOMA. But we also have a president and an administration who recognizes that LGBT families are, as Stewart said, families. They're just families and should be supported and treated as such. So there are a host of ways that the administration recognizes these relationships, and you've heard about a number of them. But there are more, too, that are less kind of high profile, but are kind of embedded within the fabric of this administration. So LGBT individuals serve at virtually every level of government and throughout the administration. When I first joined the administration, and Elaine and I and other LGBT employees would come together for meetings at the White House, we could fit around one large conference table. So 2 weeks ago, we had a meeting at the White House, and it was moved to the Indian Treaty Room, and there weren't enough seats in the room for everyone, and that represented only a fraction of the LGBT employees, or LGBT appointees, who work in this administration. LGBT families, and we have many, many, many straight allies that support the efforts of the administration in this regard as well. LGBT families are included in every major events like the White House Easter egg roll. LGBT couples have been included in White House state dinners. At any event, official or unofficial, where federal employees bring their partners and children, no one gives a second thought to the fact that LGBT federal employees are bringing theirs. And recognizing LGBT families, of course, includes also recognizing the dignity and equality of all individuals. And that's kind of where the work of the Civil Rights Division, which Stewart talked about, comes in. And I've spent a lot of time working on implementing the Matthew Shepard and James Byrd Jr. Hate Crime Prevention Act, which President Obama signed in October 2009. It was an act that was a long time in the making. And hate crimes are different than other crimes of opportunities. They affect entire communities, and communities fear being attacked. Individuals in these communities fear being attacked because of who they are, or what they look like, or who they love. And anyone who is depraved enough to commit these attacks needs to know that there are consequences for acting on violent beliefs, and that's why we have a federal hate crimes law. If a hate crime can happen to a neighbor, a colleague, a friend, or a family member, it can happen to anyone, which is why it's so important to have a law that sends a message that all individuals within a particular community, and for us, the LGBT community, are protected. So the law is remarkable in that it is the first federal civil rights law that includes the words sexual orientation and gender identity in the U.S. Code to protect LGBT individuals. We've so far indicted 9 cases, charging a total of 34 defendants, and we've convicted 15 defendants under the law. And as we speak, Justice Department investigators are looking into a number of matters under every part of the law, including matters involving attacks on individuals because of their sexual orientation or gender identity. And as Stewart noted, we brought the first LGBT-related prosecution under the Act just a couple of weeks ago. Also important to recognizing LGBT families are ensuring that LGBT individuals have equal opportunities in the workplace, which is why our employment litigation section is committed to using the authorities that it has to become involved in cases where there's discrimination against LGBT individuals on their basis of their gender nonconformity, which is what the law currently covers. And in our education section, as you'll hear later today from Greg Brooker, we're involved in efforts to ensure the equal educational opportunities for all students in schools. So that is sort of an quick overview of what the Civil Rights Division does, but I wanted to put it in the larger context of saying a lot of what's so important are the things that are more mundane but are incredibly significant steps forward for this administration. So thank you, and for LGBT families.
So now you get to be put a little bit on the hot seat with questions from our audiences. Mine are probably much nicer softballs for you. So, but I am also looking at the time, and so I'm going to ask when we pose the question to you guys, if you guys can be very short and succinct in your answers. That will help us get back on track in terms of schedule. So this is a combination of a question I have and one from the audience. So, and I think, Elaine, you can answer at least part of this. The first
I'm
question.
left-handed.
Good. I am not ambidextrous, let's just be clear. So, first of all, just how many federal government employees do we have? And then this is sort of two combined questions, but we know there's an executive order protecting sexual orientation among federal employees, but not transgender employees. So what protections or remedies might exist for our transgender federal employees? And can somebody on the panel talk about some of the changes that have happened around gender markers on passports and IDs for trans folks in our community?
Okay. Well, actually, in addition to there being an executive order that that prohibits discrimination based on sexual orientation in federal employment, there is also a statutory protection for employees who, based on sexual orientation in the civil service laws, and there has been really for quite a long time, although a lot of people don't know about it. Just this week, I'm glad you asked this question, just this past week, the EEOC ruled that claims of discrimination based on gender identity can be pursued under Title VII as claims of discrimination based on sex. And they made the decision in the context of a case involving federal employees. It's a very significant decision. The EEOC is an independent body. It's not part of the administration. Some of its appointees, obviously, were appointed by President Obama. But the significance of that decision is it not only affects the federal workplace, but it signals that the EEOC is ready to take those kinds of cases in the private sector as well. So the protection, according to the EEOC decision for transgender individuals, employees, is the same as the protection provided to people against racial or gender-based discrimination. It's a very significant decision.
I just want to add quickly that throughout the administration, federal agencies have added gender identity to their agency equal employment opportunity policies. So under those policies, it is discrimination on the basis of gender identity, like all the other categories, race, sexual orientation, ethnicity, is a prohibited personnel practice in hiring, termination, other employment-related conditions.
And then one quick addition to build on what I was saying. In addition to not being able to discriminate, most agencies and departments are adding gender identity to the list of what, for instance, HHS, we have a policy that for all HHS programs that serve Americans, that we are not to treat gender identity as that we're to serve all Americans equally regardless of gender identity, so we're extending it beyond just our agencies and departments too.
So the next question I think is actually one that is probably universal for both of these panels and everything that you guys have talked about today, which is what are the chances that the work that has been done in the last 3 years is going to be taken away or could be taken away, given that the strategy has been mostly through administration, agency, and regulatory changes? And what are some of the things that the community can know about and be supportive of that would help make them more permanent?
So I can take a crack at this quickly first, because I have some personal experience thinking about this issue. So sometimes when I talk, I get asked at a law review type symposium or law school symposium, oh, will you write a short article about this? And in moments of delusion, I sometimes have agreed to do this. So I agreed to do this after I gave a talk at this Albany Law School symposium that was held in the fall. And what I decided that I would write about was this very issue of, what staying power does executive branch action to further LGBT rights have? And as I went back and looked across various administrations, from what was done in the Clinton administration with the adoption of the executive order that added sexual orientation to federal non-discrimination provisions, or even went back to the Carter administration when they interpreted the Civil Service Reform Act, as Elaine said, to prohibit discrimination on non-merit-based factors that included sexual orientation. These actions have had staying power across administrations, and you don't see a record of new administrations that may have a different approach to LGBT rights and equality rolling things back. I mean, there may be ways in which there's not a lot of forward movement, or ways in which things may be slowed down or even to some extent undermined, but for the most part, these measures and advances have endured, and I think that is a very important point for folks to bear in mind, that the actions that this administration has taken through executive branch authority, whether it's executive orders or presidential memoranda or policies or regulations, if the trend continues, the pattern continues, they will endure. And the fact that folks in the community have come to expect and rely on these rights and protections is an incredibly important part of ensuring that that remains the case.
So, Nancy, when Secretary Solis extended and made clear what FMLA covers in terms of parents standing in loco parentis, the question, though, is that partners are still not necessarily able to take that leave if they live in a state where they're not recognized. So, can the department expand coverage to spouses and partners? Is there additional changes we can make to FMLA to make this happen? What are some of the other avenues we have to taking care of one another in addition to taking care of our kids?
Well, I think that, we're hoping that Stewart is successful, because that is the major hurdle to being able to articulate the scope of the Family Medical Leave Act, which is DOMA, that makes that more difficult. However, I mean, the important thing, of course, is to the extent that the Secretary has made clear that parents or individuals who are caring for children have a right under the Act to exercise that right and to insist on it, obviously, paves over, it's a tow path now. We want to pave it over with some asphalt. And so consequently, and that's one of the reasons for getting out the employee guide, so it's not just sort of an announcement, but it's we give clear instruction on how to implement it. And of course, obviously, the responsibility of my agency to proactively and effectively enforce the FMLA, which has been significantly, the opportunity to do so has been significantly increased with the increase in resources to my agency, the increase in the number of investigators, but also this is one place where the response to the last question makes a difference. When I started, there was little emphasis on the enforcement of the Family Medical Leave Act by the department and by the Wage and Hour Division. That's changed under my administration, and not only are we looking for individual cases to remedy them and to get corrected, but my agency is being much more proactive to look for systemic violations by employers of the rights of employees to family medical leave laws. And of course, now when we're looking for those systemic issues, because of the administrator interpretation that makes clear the protections for all parents to care for their children, we will be looking to be certain that those policies that employers have in place fully recognize that right. So those are the ways that the agency, within the limits that we're currently under, are working to be certain that there's a recognition for the families in this room.
So this is a question I'm sure many people in the audience are thinking about. I know it's something that I hear all the time when I'm traveling around the country from our families. So when and the question comes from the audience, when I travel with our family, we carry a huge envelope with all of our legal papers. How many of you do that? Right, exactly. So what things could the government do, federal government do, prior to the repeal of DOMA, obviously, that would help ensure that we continue to be recognized, especially when we're traveling or when we're going sort of out of our home safety zone, so that we don't have to bring birth certificates and adoption orders and pre-birth judgments and all the things that, medical powers of attorney, all the things that we tend to take with us to protect ourselves while we're doing that. What other things could be happening? What other things have happened that maybe folks in the room don't know about that have been important in that way? Sorry, I wasn't.
We're stumped. Well, we know that the Customs and Border Protection is now allowing us all to file a single declaration, but I don't think that quite gets at what you're talking about. I'm not really sure. I think a lot of what you're describing has to do sort of with state law and how state law is interpreted. But I'm open to suggestions. I'll take them back. What do you all have in mind? Because we have been looking through, it's across the government. We've been looking at handbooks. We've been looking at regulations, trying to figure out how to make things easier for folks. So worth going back and looking at that particular issue. Thanks for that question, Jennifer.
Sorry. And Emily's trying to mouth something over there to me, so I don't know what she's trying to say, but I wonder if she has an answer. So I will just say, sort of separate from government responses, and I think this is actually an important point, so as the moderator, I'll take a point of privilege here. There are a lot of things that government can solve for us in our community, and there are things that we can do around ways in which families are defined and how we think about that within regulation and policy. But there is some amount of our own community responsibility that we need to take in order to be able to do the job of protecting our kids and our families. And so, certainly at Family Equality Council, one of the things that we talk about is understand and know what it is that you need to have and how to be able to produce what it is that you need to have to protect yourself. In the afternoon portion of the conference, there's going to be two things that you're getting, one of which is going to be kind of this list of what has actually happened over the last 3 years, so that you know your rights, that you know what has changed and you know what you can access if, in fact, you find yourself in one of those moments of crisis. I mean, if you actually need to access FMLA for caring for one of your kids, but you don't know this change has been made, the worst time you could possibly find that out is when you actually need to take time off to care for a sick child. And likewise, there's another document that we've got available that is literally like a blueprint of what are the fundamental documents you should have in place as a parent who is LGBT, so that you at least have the checklist of what it is that you should do. And then we're going to have samples up on our website. I'll do the lawyer disclaimer. You should still go see a lawyer and get them done, in a way that's in accordance with state law and all that good stuff, but at least a checklist. And I think that's where, government isn't going to solve that problem for us. We have to solve that problem for us. So I'll add that on to the answer there.
I mean, what I would say is that the LGBT community has been extraordinarily effective in understanding how government works and understanding how you make change within government and how you help people like me implement readily some of the things that are important to the community. And therefore, I mean, when this in loco parentis administrator interpretation, it was we had meetings, there were policy papers put forward, there were suggestions about how this could be implemented by the administration. It clearly was presented by people who fully understood What were the opportunities to make change within government? What was the process by making that change? And made it made it a lot easier for those people like me who have, 7 major laws to enforce, 1 million different things that come at me every day. It allowed me to say, whoa, we can do this. And not only can we do it, but wow, here's a roadmap that's saying, here's some really good suggestions about how you might go about doing that. I mean, that, I think, tags on to the fact that that kind of effort, truly understanding how government works, how regulations are promulgated, how policies are made, where are those opportunities, and then, sort of laying it out for people like me is incredibly helpful. And it's worth the homework that the folks and organizations that represent this community engage in, and the advocates that you have in Washington and elsewhere in the country. So that sort of thing is very valuable.
And just this week we had a great example of that with the passage of the Violence Against Women Act reauthorization, which includes, for the first time, a non-discrimination provision that addresses sexual orientation and gender identity. And that was accomplished through work within the administration, but also a lot of consultation with folks in the LGBT advocacy community who identified this opportunity and worked with the administration and then with the sponsors in the Congress to ensure that that language is included and that it stayed in the bill when it came to the floor for a vote.
And let me just third that, because I think that's one of the ways that we've gotten sort of educated about things that we can do for the federal workforce. The Family Equality Council has been, Emily was hassling me last night about something, and I think it's really useful to us, and it's something we've been trying to do, is to hear from the people who are affected with their ideas. So
I'm going to do 2 more questions, one of which is really specific for Brian, and then one that's sort of more global that the panelists can wrap up. But I do want to take a minute. Somebody had submitted a question about the problems we've been having here in Anoka Hennepin, and I do want to tell you I'm going to get this question asked, but I'm going to save it for our next panel because the folks that we have on that panel are going to be able to address this question really well for you. So Brian, under the Affordable Care Act, and this is from the audience, will I be able to get insurance for my daughter even though I haven't adopted her?
Will I be able to get insurance for my daughter even though I haven't adopted her?
I'm an LGBT parent. I have a daughter. I have not done an adoption, therefore I don't have the legal recognition under state law of being her parent. Can I cover her?
What the Affordable Care Act does is, I don't know that it's going to change that circumstance, but it opens up new opportunities. So you may not be able to get your daughter covered under your plan, but for instance, it says that everyone under 133% of the federal poverty level will be covered by Medicaid. It expands Medicaid dramatically and strengthens the program. So it's possible that while you may not be able to get your daughter onto your plan, you may be able to get her enrolled in the state's Medicaid program. You can buy children-only policies that right now, starting in 2014, you'll be able to comparison shop for those. But starting right now, you can buy a child-only policy that now has banned discrimination based on pre-existing conditions for children. So that's something that's in effect right now. Insurers cannot say that they're going to charge you more or that they're going to deny your child coverage if you're looking for an individual policy. I don't think that there's anything, it won't change specifically the state rules regarding adoption, but there's the Affordable Care Act opens up through the expansion of Medicaid and through the ban on discrimination for children with pre-existing conditions that's already in effect. It opens up some significant avenues to coverage that otherwise wouldn't have existed.
And so this is the last question. It's really for all of you to answer. In thinking about some of the things that were highlighted today on the panelists' successes, one of the things that I know is that there have been very compelling stories of individuals who have either had real tragedies, and I can think of, Janice Langben Pond, who probably many of you know. That's sort of been a touchstone story for our community. I happened to be on the trip that she was on when her partner Lisa suffered the brain aneurysm and was rushed to Jackson Memorial Hospital in Miami. The president talked very specifically about that experience and how Janice was denied access to Lisa in her final hours. I know, Nancy, when we were working with the Department of Labor, you know, we had the story of a couple, Naz and Lydia, who, when their twins were born very prematurely, Lydia was unable to take any time off from work to be with the children because she lived in a state where she wasn't recognized or able to be recognized as a legal parent. So can you talk a little bit about the importance of these stories? How instrumental are they actually in helping educate, illuminate, and move the American public and therefore help support the administration's work? And what's the best way really for those stories to get told, heard, and shared with key people in the administration to make those changes?
First of all, the stories are very important. Bringing humanity to all of these issues is critical to demonstrate how I think, you know, sort of this sense of common decency, common humanity are always stories that are compelling to the majority of the American people. And so consequently, and a lot of them are you know, my experience is the typical reaction is, well, why wouldn't we do that? Why wouldn't that be important? How come, you know, that isn't something we as a community or we as a country wouldn't think is critical sort of common decency? And so consequently, those stories are very important. I think that obviously the stories too help inform policy because we can then make decisions based on the facts and the specifics of what are going on so that we don't miss opportunities just because we didn't simply understand you know, what was going on in the real world. So consequently, I think that those stories really do inform, you know, compel and inform the decisions that we make. How to get them to the policymakers, I guess one of the things is keep banging on the door. That's very effective. There is a certain truth to the squeaky wheel gets the grease. But I think too that, you know, again, like I said earlier, understanding how government works, understanding how policy is made, and then looking for those opportunities with that understanding clearly is a very effective strategy.
I think.
Go ahead, Ray.
I think as the only PR person on this panel, I have a unique perspective on this. It absolutely makes a critical difference. It's one thing to say the Affordable Care Act does not allow discrimination based on pre-existing conditions. It's another thing to hear, I have health care now, and without the Affordable Care Act, I would not have been able to get health care. It makes an enormous difference. It makes an enormous difference in terms of changing public opinion, and it makes an enormous difference in terms of changing policymakers' minds. In terms of how to get that message to the policymakers, I know I think on whitehouse.gov, on a lot of our department websites, on the press section, there's sometimes a share your story. I believe there's something on the White House blog or somewhere on whitehouse.gov where that's available. Also, your members of Congress. I know Senator Franken's going to speak here in a minute, but a lot of times your senators, your congressmen, even your local representatives, they sometimes are able to get in with the policymakers in Washington and really, really make a difference.
Yeah, and one quick point. I mean, for us in the Civil Rights Division, the Justice Department, I mean, these aren't stories. These are the lifeblood of the work we do, right? So in all the hate crimes training work that we've done, we've emphasized the importance of people being willing to come forward and tell law enforcement what's happened to them. So it's important that they have trust in law enforcement, that they be willing to come forward and tell the authorities what has happened to them or tell their community stakeholders what's happened so that they can in turn tell the authorities so that we can look into the matter. Same is true in our work in school districts. We need to hear that there has been harassment and bullying in a place like Anoka Hennepin so that we can go and investigate it. So coming forward and telling us what the stories are makes us able to do the important work that we do to protect civil rights.
So I want to ask everybody to join me. Please thank Brian, Elaine, Nancy, and Matt. So, and I'm going to ask folks to, weather the auditorium seating here for about another 15 minutes. I'd like to invite to the stage Kevin Miller, who is the chair of our Midwest Advisory Council here in Minnesota, and to introduce our next very esteemed speaker.
Good morning. My name is Kevin Miller, and I'm chair of the Midwest Advisory Council. In 2008, Al Franken was elected to represent the great state of Minnesota in the United States Senate, where he has worked across the aisle to improve the lives of Minnesotans on a broad range of issues, such as assisting disabled veterans and ensuring that women in the military can have access to comprehensive medical care. He has also worked successfully on both health care and Wall Street reform. Among his numerous other achievements, Senator Franken has been and continues to be a staunch advocate and a leading voice in the fight for LGBT equality, and has proven time and again that he supports equal treatment across the board for LGBT people and their families. He voted to repeal Don't Ask, Don't Tell, is a leader in eliminating all remaining barriers to LGBT people being able to foster and adopt children. He supports marriage equality and the repeal of Defense of Marriage Act, and tax equity and equal employment for housing rights for LGBT families. And on May 20th, 2010, in response to numerous reports of LGBT students taking their own lives as a result of pervasive bullying and harassment in school, several here in Minnesota, Senator Franken introduced the Student Non-Discrimination Act, a federal bill that would establish comprehensive federal prohibition against discrimination in public schools based on actual or perceived sexual orientation or gender identity. The bill would also forbid students from discriminating against friends and allies of LGBT students, including students with LGBT parents. Current federal civil rights statutes do not explicitly include sexual orientation or gender identity protection, leaving LGBT students and their parents with limited legal recourse for this kind of discrimination, harassment, and bullying. 50 years of civil rights history shows that similar laws are effective in preventing discrimination from happening in the first place. And just 1 week ago yesterday, this important piece of legislation received formal endorsement from the White House. Ladies and gentlemen, please give a very warm welcome to our very own Minnesota Senator, Al Franken.
Thank you, Kevin. Thank you. Thank you. Sit down. Save it for the end. Thank you, Kevin, for that kind introduction. I'd like to thank the Family Equality Council and, of course, the White House for the kind invitation to join you all here today. I see I've been strategically positioned between the Supporting Youth panel and the Recognizing Families panel, and so I'd like to talk about both of these things, about protecting LGBT children in our schools and about protecting LGBT families. I hope a lot of you have seen the movie Bully, which is out right now and which deals in part about the wave of bullying, harassment, and discrimination that is affecting lesbian, gay, bisexual, and transgender children in our nation's schools. And you know, there's a lot of people who say, well, what can you do about bullying? I mean, it happens, and kids will be kids, boys will be boys. I don't think that's right, and I think that breaks down under some examination, because what we're seeing in our schools today isn't just teasing, it's not just playground behavior, and what we're seeing is more than just bullying. We're seeing discrimination. And let me explain what I mean. If a white child called a black child a racial slur and told him he had to sit in the back of the bus, would we say, oh, kids will just be kids? If a Jewish child got beat up because he wore a yarmulke to school, would we wave it off and said, boys will be boys? If a shop teacher told a female student that she didn't belong in his class, would we be fine if the school just looked the other way? Of course we wouldn't. In fact, there are federal civil rights laws that are specifically designed to stop this kind of contact, and I'm talking about Title VI and Title IV and Title IX. But if a gay child is relentlessly harassed by classmates, if a principal tells a girl that she can't go to her senior prom because she wants to bring a girl as her date, or if a school just stands by as teachers and students and other administrators refer to a transgender child as not he or she, but it, there is no law that was written to protect these children. Our laws fail these children, and that's just wrong. I have a bill, the Student Non-Discrimination Act, that would fix this. It takes the same protections that children have against discrimination on the basis of their race, on national origin, religion, gender, and disability, and extends them to cover LGBT children. That's it. It's a pretty simple law. Now, when I first introduced this law, some folks came up to me and said, this is a nice bill. You'll be lucky to get 5 or 10 sponsors. And you know what? We didn't get 5 or 10 co-sponsors. In the Senate, we've gotten 37 co-sponsors. And in the House, we have far more, and we have bipartisan support. And last Friday, the President of the United States officially endorsed the Student Non-Discrimination Act. This isn't going to be one of those bills that just languishes in the Senate. We're going to pass this thing. It may take a year, it may take a few years, but we're going to do it. Vote by vote, we're going to get there. Having the support of the President is a huge milestone in that fight, and one that we should celebrate, and I want to recognize and thank the President for his leadership on this issue and for being a true friend of the LGBT community. But I'm not here just to talk about Senda, because we've got another fight, one that is specific to Minnesota, and I'm talking about the anti-marriage amendment that's on our ballot this November. In the Senate, I sit on the Judiciary Committee. We're the committee that holds confirmation hearings for Supreme Court justices. So part of my job is keeping up with the Supreme Court and going back and reading some history. I didn't, my background, I didn't, believe it or not, go to law school. And so I try to catch up on my history. Now, a lot of people have been paying attention to the fight over Proposition 8, which may eventually go to the court. But I think it's worthwhile to remember another case about a different state that tried to ban marriages between loving, committed partners. That was Loving v. Virginia, and it was decided 45 years ago in 1967. Even though they met and lived and fell in love in Virginia, the Lovings, Mildred and Richard Loving, got married in Washington, D.C. Because of Virginia's, quote, Racial Integrity Act. That was the name of it. The act said that because they were different races, I remember the judge in this, I'm departing from my prepared remarks here, but I remember that the judge in this wrote in the decision that the different races were not meant to marry because they came from different continents. So God did not mean for them to marry. You know, and that makes some sense. And what was very odd about the laws of that time is they would say the yellow people and red and white, and Caucasian and I can't remember what, but for some reason the Malays, I don't know if there are any lawyers here, but in those days there was a lot of reference to the Malays that were on a different continent. I think there had just been a lot of immigration of Malays at the time. But anyway, so if you go back and read the law, it shows you sort of, you know, I used to be in a different job, and sometimes absurdity catches my eye. Read those cases, and it's fun reading. It's tragic, but there's nothing wrong with getting a kick out of misguided thinking. So anyway, the Lovings, long story short, the Lovings knew they couldn't get married in Virginia, and so they got married in D.C., but they were both from D.C., so soon after, they were both from Virginia, so soon after their wedding, they were back in Virginia, and Mildred and Richard were woken up and surrounded in their own bedroom by deputy sheriffs, and they were arrested for the crime of marrying the wrong person. The Loving family took their case to court, and the state of Virginia did too. The Loving family argued that we're all human and that we're all equal, and that the Constitution says something about that. And that it is not a state's business to tell a person whom that person can love and whom that person can marry. The state of Virginia argued the Lovings' marriage was unnatural, races on different continents, that it was wrong, and that it was the state's right and prerogative to stop it. You know who won the case? Loving. You know what the vote was in the Supreme Court? 9-0. That was 1967. Now let me read you something that Mildred Loving said in 2007. It's a quote. "My generation was bitterly divided over something that should have been so clear and right. The majority believed that it was God's plan to keep people apart, and that government should discriminate against people in love. But I have lived long enough now to see big changes. The older generation's fears and prejudice have given way, and today's young people realize that if someone loves someone, they have a right to marry. Surrounded as I am by wonderful children and grandchildren, not a day goes by that I don't think of Richard and our love. our right to marry and how much it meant to me to have that freedom to marry the person precious to me, even if others thought he was the wrong kind of person for me to marry. I believe all Americans, no matter their race, no matter their sex, no matter their sexual orientation, should have that same freedom to marry. Government has no business imposing some people's religious beliefs over others. I support the freedom to marry for all, end quote. Folks, this November, Minnesota has a choice. We can be loving, or we can be Virginia. And it's up to many of the people in this room to make sure that we get that choice right. I'm going to do everything in my power to make sure that we do. Thank you.
So thank you, Senator Franken. Thank you all for being here and for participating this morning. We are now going to take a short 10-minute break. There are refreshments in the hallway. It's a great time to stretch your legs and have a few minutes. And if everybody could plan on being back here at 5 after 10, we'll get started with the second half of our morning and take the next portion of the program underway. So thank you for being here.
At the United States Department of Agriculture. And for the next speaker, we have an introduction. Thank you, Ella.
Hi. Good morning. My name is Ella Robinson, and I'm co-chair of Family Equality Council's Outspoken Generation. Yay! I am honored and excited to be introducing Brian Samuels, Commissioner of the Administration on Children, Youth, and Families in the U.S. Department of Health and Human Services. A foster child himself, Commissioner Samuels served from 2003 to 2007 as the director of the Illinois Department of Children and Family Services. He then served as the Chief of Staff for Chicago Public Schools, managing the day-to-day operations of the third largest school system in the nation. Since his appointment to the Administration on Children, Youth, and Families, Commissioner Samuels has headed the administration's charge of improving services and programming for the over 408,000 children in foster care across the country. Under his inspired direction, the Administration on Children, Youth, and Families has been steadfastly supportive of LGBT youth and families. In April 2011, ACF released a groundbreaking memorandum detailing best practices for supporting LGBT foster youth and recruiting LGBT foster and adoptive parents. In June of 2011, ACF awarded its first ever grant to the Heartland Alliance of Chicago to create a training and technical assistance center to support the resettlement of lesbian, gay, bisexual, and transgendered refugees. And Commissioner Samuels has spoken out against the epidemic of LGBT homeless youth in our country, participating in the first ever White House LGBT conference on housing and homelessness. We are honored to have him here this morning, and we look forward to working together to create a nation in which every child can find a permanent and loving home. Without further ado, may I introduce Commissioner Brian Samuels.
So good morning, everyone. And thanks for the opportunity to come and talk to you, and thanks for all of the energy and support that you provide to the administration. You know, I think in many respects the work that we're doing is important, but it's more important that the community of folks that we're affecting own the change, that experience the change, and ultimately will continue to advocate for the change. So it's great to have a chance to talk to you this morning. In some respects, I'm going to shift the focus a little bit from the earlier discussion in the sense that as the Commissioner for the Administration on Children, Youth, and Families, I'm responsible for the work around child welfare, so all of the work that we do with states, as well as the work around the runaway and homeless youth population, domestic violence population, and we're responsible for about half of the teen pregnancy prevention funding in the agency. And so in the big picture, my responsibilities really focus on a population of kids for which bad stuff has already happened. Right, so much of what is talked about earlier is really about trying to get ahead of the curve. It's about ensuring access. It's about guaranteeing that our rights are protected across all communities. But in this particular instance, I'm really challenged with trying to find a way to work for a group of young people who really need our help and need a different way of supporting their strength and their development. And so that's really our focus. And so in many respects, we have focused on how do we reshape the way we do policy, practice, and programs in the areas that I'm responsible for so that we can get better results. And so we start from the context of a population of young people who have been exposed to lots of violence. And the typical response in that context is really to focus on all of the bad stuff, the risk factors, right? So this slide here is just a summary of data that you could find in any published journal about the LGBTQ population relative to runaways. And so, this is the way we talk about this community, right? And this is the way we talk about what we ought to be doing for this community. And my life experience tells me that this is exactly the wrong way to think about getting to better results. And so what we're trying to do is shift the paradigm to think about serving young people in a fundamentally different way. And so let me talk a little bit about both the change and the logic behind the change. As was indicated, I spent 2.5 years at the Chicago Public Schools. And it was a great experience. I learned a ton of things. But during that experience, one of the things that happened was that, back up for a second, the current Secretary of Education, Arne Duncan, was the CEO at the Chicago Public Schools. And I came there on the premise that my job was to run the day-to-day stuff so that Arne could really drive and focus on the vision and work that was really important to him. And one of the things that he made most important above all other things is getting to better educational outcomes for all kids in the Chicago public school system. And he was open to trying anything to get to those better results. So he did things like pay students for grades. Hey, maybe it works, maybe it doesn't, but let's try it. A big part of his strategy was also charter schools, creating an alternative system of education so that children and their families had options other than the traditional public school system. And so when I arrived at the Chicago Public Schools, we had well over 90 charter schools, largest charter school system in the country. The entire state of Illinois, at the time that I was there, only had 2 charter schools. And so Chicago was really a driving force there. And so on an annual basis, we put out solicitation asking for community groups and interested parties to come together to make proposals about starting and implementing charter schools. And so in one of the particular experiences I had the second year that I was there was that the gay, lesbian, bisexual, and transgendered community came together with the educational community to propose a strategy around a charter school that would be gay-friendly, that would be bisexual-friendly, would be transgendered-friendly. And the typical process was that they'd go fill out this application and make all of these decisions. The Chicago public school system would get those applications. We would process them all and make sure that they all met the minimum obligations under the charter school charter. And then based on that, we would move them forward to the board for consideration. And in the time that I was there was no charter proposal that once it met the minimum requirements didn't go to the board for consideration. So when this proposal came forward from the gay, lesbian, bisexual, and transgendered community in conjunction with educators to propose a school that would be gay-friendly, it was logical. They met all of the requirements. They met the minimum obligations, so that proposal went forward to the board. And what would typically happen would be that those presentations would be made at one board hearing, and then the proposals themselves would be voted on in the next hearing. And so there was a month between each of the hearings. And so in this particular instance, the proposal came forward. We thought it was totally the right time to do this thing. It met all the minimum obligations. We took it forward to the board. We presented it at the board meeting, and the world exploded on us. And so even though we had charter schools that were focused on each of the service branches of the military, community was fine with that. We had charter schools that were just for black boys. Community was fine with that. We had charter schools that were just focused on the arts. We had a charter school that was just focused on the choir. But when we came forward with this proposal, the world exploded. And folks came out of the woodworks in a way that you'd be absolutely amazed by. I mean, they came from everywhere, right? Including the religious community. But the reality was they also came from within the school system. So, you know, we had folks in our own building that didn't think this was a good idea. They were worried that we were condoning a lifestyle. We had board members. We had board members, folks sitting on the board, who were concerned about what message supporting this proposal would send to the rest of the community. And then, you know, there was so much acrimony that in the end, the group pulled the proposal. And so it didn't go forward to the board for voting in that month. But that period between when it was proposed and when they pulled it, Arnie felt like we really needed to get out into the community and to tell the story of young people who were struggling to succeed in a school system that didn't recognize their developmental needs, didn't recognize the impact of being gay, lesbian, bisexual, and transgendered, didn't appreciate the developmental stress that just comes from knowing that you're different, and then deciding to come out or deciding not to come out, and all of the energy that goes into concealing your sexual orientation. And all of the energy that's focused on that means that all of those other developmental experiences that you should be having in order to be healthy and productive as an adult gets used on all of this other stuff. And so in talking to those young people, and then me coming back and trying to find the literature to support why a gay-friendly environment may be absolutely a right option for some young people. Also remember, with charter schools, at least in Chicago, you voluntarily apply to go to a charter school. So it wasn't a situation where we'd be imposing the strategy on anybody. It wasn't that we'd be making kids who were gay or not gay, you know, straight or bisexual. It wasn't that we'd be making them go to this school. Their parents actually have to say, yeah, we want Johnny, Susan, or somebody else to go to that school. And so we came at it from a developmental standpoint, and we tried to make the argument to folks inside the building that this was developmentally appropriate, and more importantly, it was about getting to better results. For these kids, putting them in an environment where they weren't concealing their sexual orientation, where they weren't focusing energy on the bad stuff that was happening with them, and instead focusing on the good stuff that was happening to them, totally the right thing to do. But the most fascinating part of this story for me was that it was one of the first times I had actually seen equal treatment used against the minority community. Because in this particular instance, those who came out against this came out against it from a frame of, well, if we created a school like that, wouldn't that be unequal treatment? No. Equal treatment means that they should be able to go to any high school. Regardless of what that high school is teaching, they ought to go to any high school. And so the argument was that it was actually unfair to them. They would be treated unequally by creating a school that was sensitive to their developmental needs and that focused on the kinds of things that would be really important for them to succeed. And so, you know, that experience was profound for me and an important part of what I bring to the table here. And so that's one side of life. The other side of life was I was a child welfare director in Illinois. And the work there was important, also really great experience. But the work there was for another group of young people that were really challenged all the way across the board. But while I was there, the emergence of the issues around the gay, lesbian, bisexual, and transgendered young people was really profound for me in the sense that I saw all of the challenges that they were experiencing and how they were trying to cope with those challenges. And so from those two experiences, you know, I got to a place in my understanding of policy and practice and programs to think about we really ought not to be focusing on the bad stuff and trying to just fix the bad stuff, that we ought to really be focused on the protective stuff, building strengths, identifying assets, and really enabling young people to succeed. And so when you take it from that perspective, what we come to understand, at least for the kids who are really exposed to bad stuff, that social support and connectedness is a critical component to success. So when you look at bad stuff happening to runaway and homeless youth kids, the ones who actually get off the street the fastest are those that actually have a social support network and are connected to a community of support. When you look at kids who get off the street, you also see that they either have a family support or they have a friendship network that makes a huge difference. And that's what draws them in. And what was really shocking about the work in child welfare was that for the children who had entered the foster care system, you know, on any given day, about 4% of them are on run. They've run away from the system. And so we have to go out and find them and bring them back in the system. And when I got there, there were well over 400 kids that we hadn't seen for at least 2 months. And so we set out a strategy of putting our hands on every single one of them. And what was really surprising about that work was the disproportionate representation of the LGBT and Q youth in that runaway population. And when you looked at more closely at the experience that they were having, they were running away from their placements, they were running away from communities where they didn't think that they were supported, and they were running to the one community that they thought would support them, which is on the north side of Chicago. The gay, lesbian, bisexual, and transgender community is concentrated on the north side of Chicago. And you'd have kids from the central Illinois and southern Illinois who had heard about the north side of Chicago. And they would put themselves in the way of great harm to try to get to the north side of Chicago. But the worst part of it is when they got to the north side of Chicago, no money, no resources, no support network, no nothing. And so rather than getting to a place where they'd be in safe harbor, they were actually in more harm's way. And so trying to rethink, so can I understand what's at the root of that challenge? And how do we build a system that recognizes and addresses the root cause of that behavior? Because that's the only way we're going to get to a good result for these kids. I mean, it was incredible. You know, they would do whatever they had to do. And honestly, this was fascinating. We found 4 young people who had gathered together in southern Illinois, got all the way to Chicago and up there. We went and found them, we engaged them. We weren't quite sure what to do quite at that point. So we ultimately transitioned them back to Southern Illinois. And a month later, we were back on the north side of Chicago, picking up these 4 young people, trying to figure out where to go. We didn't take them back to Southern Illinois the second time. We're a little slow in figuring things out, all right? But we did not take them back to Southern Illinois. But you can imagine, right, that if these 4 young people are willing to do that, you know, we just imagined twice, we just imagined how much more of that was going on inside of young people, regardless of whether they were trying to pick up and go to Southern Illinois. And so, you know, for us, it was about beginning to try to think through placements differently, to try to think through how do you build a social support network for young people so that they feel like they belong and they feel like they're in a place where they can actually grow and develop in a healthy way. You know, to think about how do you build self-esteem in the context of bad stuff already happening. And really trying to think through how do you give young people a set of experiences that give them the belief that they can succeed, right? So self-esteem is typically talked about as feeling good about yourself, but efficacy is talked about as in you know that that good stuff actually translates into good results. And so for us, it's not just about trying to figure out how to make them feel better, but how to give them a set of experiences that let them know that they can, in fact, succeed if they take what they have and they go forward in the world in a positive way. And so that's really what we're trying to do. This is 2 set of slides that just kind of emphasize, if you take those earlier protective factors that I described, and you think about, those are all about feeling good about yourself. Those are about being grounded in a place where you understand who you are and where you're going, and that you're surrounded by a group of people who care and love and support you. And this is a study from Caitlin Ryan that shows that young people who feel supported do better than those who don't feel supported, particularly in the gay, lesbian, bisexual community. So this just tries to show you that if you look at young people who are gay, lesbian, bisexual, and have experienced low rejection or moderate rejection versus high rejection, you see what their vulnerabilities are around issues of suicidality, around thinking about or attempting suicide and depression. You can see the young people who experience the most alienation and rejection are those that are most vulnerable. So there's diversity within the population, but those who've experienced the worst of this stuff, said differently, those that didn't have access to those protective factors are the ones that we ought to care about. So these, you know, rejection is real, and it translates into results that are real and damaging. And so we're trying to think through at the Administration on Children, Youth, and Families, how do we take those protective factors and begin to integrate them into everything that we do, in all of the funding announcements that we make, in all of the policies that we set, and in all the training support that we give to runaway and homeless youth programs or to children who are in the child welfare system. We're trying to figure out how we get away from this stuff, but not by trying to address whether suicide is going to be attempted or whether depression is important. Rather than targeting the symptom of the problem, we want to build a system that builds into it the capacity for protection, focusing on building the assets that young people from this community need in order to succeed. So that's the work that we're doing. You probably don't hear a lot about it, but I appreciate you taking the time to hear about the work and to know that there are those of us who don't quite garner lots of attention are working equally as hard with others to make sure that this really is an agenda that gets to all of our kids and families, whether it's about protecting them before bad stuff happens to them, or whether they land in the places where I'm responsible, and we try to get to positive results after bad stuff has happened to them. So thanks, and enjoy the rest of the conference.
The long climb to the microphone. So I am really excited to now bring to you our second panel. which is about supporting LGBT youth and families. And I want to ask our panelists, Greg Brooker, Brian Samuels, and Deborah Temkin, to come up to the stage. And this panel is going to run exactly like the one previously. I keep wanting to say this morning as if it's afternoon, but it's not. Maybe it just feels that way to me. So we're going to hear from each of our panelists a little bit, and then we'll open it up to questions from the audience, and I have some questions. But just so everybody knows who's at the table here, we have Greg Brooker, who is the Chief Civil Division of the Office of the U.S. Attorney for the District of Minnesota. We have, of course, Brian Samuels, who you just heard a fabulous address from, so I won't say more about him because his incredible skills are very obvious to all of us. And then we have Deborah Temkin, who is the Bullying Prevention Coordinator in the Office of Safe and Healthy Schools at the U.S. Department of Education. And we're really thrilled to have all three of them here with us today, so please give them a warm Minnesota welcome. So I think, Greg, we're going to start with you.
Oh, all right. I was one of the litigators in the Anoka Hennepin case. Many of you know what that was about, but just some quick background. The Minnesotans here know that it's the state's largest school district, 40,000 students, 37 middle schools and school buildings, high schools, elementaries, spread along a vast, large territory. It is the department's largest settlement consent decree dealing with this large of a school district, so it presented some issues for us. Just by way of background, the complaints came in through many different paths, as Deborah can talk about, from the Department of Education. And there were private actions filed last July from student plaintiffs, and they were represented by the National Lesbian Rights Center and the Southern Poverty Law Center. And so that suit was filed last summer. But a year prior to that, Deborah's department, the Department of Education Office of Civil Rights, and the Department of Justice were quietly investigating complaints and were interviewing 60-some-odd students, parents, and teachers and staff members. And so when the lawsuit was filed, it was a private lawsuit and the government wasn't involved. I received a call, however, from a federal magistrate judge saying the private parties don't want to settle this action without the United States government involved. We know that you are out there investigating this school district. The school district doesn't just want to settle with the private groups. They want to settle everything in one big package. So we were invited as a non-party to the federal settlement conferences that occurred from August of last year until March of this year. There were 12 sessions and many other meetings and phone calls in between. What finally happened was a 61-page consent decree signed by Judge Joan Erickson of the Federal District Court in Minnesota. Just quickly, some highlights as to what's in here. It's a 5-year consent decree, so the United States will be monitoring compliance with this agreement, with this court order rather, for 5 long years. There are several provisions, and I'll just highlight a few, and then we'll go on to the rest of the panel. Some unique aspects of this agreement, the mental health coordinators and consultants. One of the findings of the government was that counselors weren't available during school hours because they were pulled to proctor exams and all the standardized tests that are conducted. Just as an aside, my daughter went to this elementary school. She's now 21. We were at the old school. We parents took on central administration to get a new building built here. It's a great facility, but I can remember her coming home with all these standardized tests, and I'd have to try to interpret them. So what we found up in Anoka was a lot of the counselors were not available when kids were trying to reach them who were depressed, who may have contemplated suicide. This court order now requires that one qualified mental health consultant be available at all times in all these buildings during school hours, and they have to hire a highly qualified mental health consultant who will do annual reports to the board and the government about what is working and what is not. There are student anti-bullying surveys that must be conducted under this agreement. They have to be written so that they try to identify some hot spots, harassment hot spots in these buildings. As you know, it may be the bus one day, but it could move several months later into a parking lot or a certain hallway or a certain area that's not monitored as well in a large high school. In fairness to this district, there are, as I mentioned, 37 buildings, 40,000 students. So we hope that this constant identification with student and parent and staff involvement of hotspots, you can then move your personnel there accordingly to squelch that one and then anticipate where it's going to move on to. There are student and parent task forces on anti-harassment that get so detailed as to membership and how often they have to meet. And there's massive training of staff and, most importantly, of course, to students, age-appropriate training and education on these issues. And they have to hire several consultants to work with them throughout these 5 years, and those consultants will be filing reports to the Department of Education as well as Justice. Thank you.
Deborah? Sure. So, as Greg nicely outlined, going on the compliance end and looking at cases that do not comply with our federal civil rights laws is a very important aspect of our bullying work. But it's not the only thing. We know right now, as it stands, federal civil rights laws only cover a very small portion of what we consider bullying. Bullying and harassment are two very different things. Bullying, as defined, is any aggressive behavior between school-age kids that occurs within a power imbalance. That means that the person who is bullying the other has more power over them, and that can look like physical strength, popularity, and that also can include being a member of a majority against a minority. And we say that this happens repetitively or has the potential to be repeated over time. We don't say that bullying has to be targeted at a characteristic. Bullying can happen for any reason, but we know that certain groups are targeted more often than others. Well, in terms of harassment, there is a legal definition of harassment, according to the federal government, in terms of our federal civil rights laws. And that's what we heard about with the Anoka Hennepin case, that the school district violated those students' Title IX rights for not addressing harassment based on those students' conformity to gender norms, is the way that it's phrased. We try to address this whole broad spectrum. We try to prevent bullying not only among LGBT students and students from LGBT families, but all students. Because as my boss, Secretary of Education Arne Duncan, likes to say, no school can be a successful school until it is a safe school. That means every single student feels that they are safe and want to be there. No student can achieve if they are fearing what is going to be said to them in the next period. No student can achieve if they are worried they're going to get shoved into a locker. And no student is going to achieve if they are feeling like they have no one to sit with at lunch and they don't want to go. We have taken many, many steps, and I don't want to go through all of them because I do want to give you time to ask questions. But I want to highlight just a few. This administration has made a commitment to addressing bullying and making sure we say that bullying is not a rite of passage, it is not normative, and we can no longer sweep it under the rug. We have had 3 events to raise this awareness and send that message. Our first being in August of 2010, where the Federal Partners in Bullying Prevention, which is a coalition currently of 9 federal departments. Now let me repeat that. 9 federal departments are working together on this. That's unprecedented. Our first event was in August 2010. Second event was the March 2011 White House Conference on Bullying Prevention, where the president himself got up there and said, bullying is not okay. That's huge. This is unprecedented. This is the first time an issue like this has been brought into the East Room of the White House to say this is an issue that everyone has to address. We also followed that up with another conference in September 2011. We have also launched and relaunched within the past month stopbullying.gov. If you're looking for resources on bullying, that is your one-stop shop. And we have relaunched it to make sure there are concrete action steps for everyone to take around bullying. Because we know this is not just the responsibility of the schools. This is not just the responsibility of parents. It's not just the responsibility of the students themselves. It's not just the responsibility of the community. Everyone has to work together and send a consistent message around this. If we're not working together, if we're not taking steps, we're never going to solve this problem. And so we can't just blame the schools. We can't just blame the parents. Everyone needs to work together on this. And just this month, just to highlight our commitment to making sure that LGBT students receive the education that they deserve, our Department of Education released its updated strategic plan where it makes clear that we strive to make sure that every student has equal access to education no matter their race, gender, sexual orientation, or gender identity. And as you heard from many speakers before, the White House last week announced its endorsement for both the Safe Schools Improvement Act and the Student Non-Discrimination Act, which would put specific enumeration for sexual orientation and gender identity into anti-bullying and civil rights laws. I do want to highlight quickly that we did, in December of 2010, release a memo. Secretary Duncan released a memo outlining the key components of anti-bullying laws and listed enumeration as one of those key components. In 2011, we released a report that outlined what components each state law had. I always do my research before I come to these events to see the type of place I'm coming. I'm sure this is no surprise to any of you, but Minnesota has the shortest law in the country that does not have a definition and has the least amount of those key components. So there's no official comment on that, but I leave you with that piece of information. Thank you.
So I just want to take a couple of minutes and talk through some of the concrete steps we've taken to really talk about approaching this community in a different way, particularly for young people who've already experienced really bad stuff. So as was indicated in the introduction, early in the administration, we sent out an information memorandum to all state child welfare agencies, reminding them of their responsibility to serve LGBTQ youth in the exact same way that they serve all other youth, and to create an expectation that when and where we found them to be short of meeting the needs of that population, to really hold them accountable for that. So we laid out all of the obligations that they had for serving youth from this community in child welfare. We followed that up by the recognition that while that sounds really interesting, building capacity for agencies to really do that in an effective way is an important step. And so one of the other things that we have been able to do is that during that first year, we were able to cobble together a pool of funds of about $100 million over 5 years to target those young people who spent the longest amount of time in the foster care system or who reached permanency at the lowest rates. And given the fact that the LGBTQ youth fit that category, we were hopeful that folks would come forward with a great proposal to address that issue. And so we ended up funding 5 programs around the country, but the one that we funded in LA specifically targets the LGBTQ youth, and it is around building services, supports, and interventions that increase the likelihood that these young people leave the child welfare system as fast as everybody else does, and that they leave them to stable and supportive households like everybody else does. And so we're excited about that work. They're in year 2 now of that work, and they've just begun the implementation process. We've already learned a lot. You know, their challenge is, how do you identify this population in context of child welfare? We don't ask whether you're gay, lesbian, or bisexual, or transgendered when you enter foster care. And we really don't have a way of identifying them. So they've struggled with how to do that in the context of their work, as well as to try to drill down and find data that is supportive of and informs their practice in this area. And so they've made a lot of progress, and we're hoping that based on that progress and the early implementation success, that we can begin to share all of this early effort with other child welfare agencies so that they can begin to move in the same direction as LA is. So one important component of that. In addition to that, we have, for the first time, provided states the latitude to spend federal child welfare dollars that are dedicated for training and capacity building of child welfare agencies and providers, so that those funds, which have always existed, that are supposed to be building capacity for child welfare agencies to succeed, we actually worked in conjunction with the Human Rights Campaign to work with them to develop training around how to recruit LGBT families to child welfare. And they have, for the first time, provided that training to a state so that that state can begin to more effectively do outreach to the community and to begin to bring into child welfare those families that are willing to make a commitment to this vulnerable population and families that are really committed to making a difference. And so that's also exciting. It's only the first state that we've been able to do this, but we think that based on that state, we think there's potential for a whole bunch of other places to do this. That state is the state of New Jersey. So actually, Chris Christie actually let this happen. And so our thinking is, if Chris Christie is willing to do this, we just think he's shown great leadership in this area, and if he, and we're hoping that we can build on that success. The other thing I would point out is we have put some additional resources in terms of grant making to agencies to help them do more family finding for youth who are gay, lesbian, or bisexual in child welfare, to really begin to mine their cases and try to find other family members who are willing to support them and care for them and help them transition out of the foster care system. So we think that's important. We've also made some significant changes and progress around the work that we're doing in the runaway and homeless youth population. So for the first time, we've actually made grants to organizations that are dedicated exclusively to doing street outreach for LGBTQ youth, to really begin to target those young people and find how to meet their needs in ways that draw them off of the street and to safe spaces. In addition to that, we're in the middle of rewriting the regulations around the oversight of LGBTQ youth in the context of runaway and homeless youth programs. So as we write the new regulations around the runaway and homeless youth program, making sure that the issues related to the LGBTQ youth are addressed within those regulations. So that's a process that's going forward currently. And in addition to that, we've also began to work with the transitional living programs in this area to help build their capacity to recognize the trauma and the impact of trauma on this particular community, and build their capacity to see that as an explicit component of their service intervention strategy. And lastly, under the Affordable Care Act, most folks don't know this, but the Congress funded expanded support for teen pregnancy prevention, and they did it in two categories. One, which focused on comprehensive sex education, and the other focused on abstinence education. The funding on abstinence education was the same amount that was funded under the Bush administration, but with the benefit of input from lawyers, we looked closely at both of those pieces of legislation, and they make clear in that legislation that both of those programs should target the most vulnerable. And so our interpretation of the most vulnerable is that those programs have to address the needs of the LGBTQ youth if they're going to use federal dollars to focus on this issue. And so we actually have abstinence education programs today that are acknowledging that gay, lesbian, bisexual youth exist and are communicating appropriately. But I think all the more important on the comprehensive sex education. To be honest, even though we know that that has a stronger evidence base to it, most of those programs don't explicitly recognize the unique challenges that come with LGBTQ youth. And so we have made it as a part of their contractual obligation that they have strategies for integrating appropriate materials into all of their training so that they're communicating effectively to this community and meeting their needs in a way that promote safe, appropriate sexual activities in a group of young people that need support. So we think in all of those areas, none of them rise to the level of being able to say we've changed the system universally. But you know, our approach has been in child welfare and in the runaway and homeless youth work that we're doing is just chipping away by finding every opportunity possible to address this issue. And we hope, you know, over time, we have fully integrated the concerns here in a way that regardless of who wins the election, we have folks out there doing this work in ways that demonstrate that this community, that their needs are being met and that their concerns are being addressed. So thanks.
That's great. Thank you. So Greg and Deborah, we had a question earlier this morning specifically about the Anoka Hennepin case. I suspect if I did a quick survey of this room that they would find a lot of energy still around what has happened and what I think folks continue to see happening here. So if you don't mind, we're going to stay focused on that piece for just a few minutes because there's some really specific questions people have. One question that we had from the audience is that despite the recent settlement, we continue to have problems in the Anoka Hennepin School District. The audience members' view is because of the misuse of the Federal Equal Access Act and allowing sort of religious-based bigotry to influence how students are being treated. And the question is what more can we do? How can we be involved in helping make this better? And then sort of the follow-up question is, how are you monitoring the settlement? You know, I heard you talk, Greg, specifically about the different reports that are going to be coming, but sort of what is the monitoring process? How often are people checking in? There is some sense, I think, among the audience that the school board is not super enthusiastic and sort of is not really thrilled about what they're having to do and therefore could have less than stellar results around what's going to be going on in terms of monitoring and really embracing the outcomes of the settlement.
Okay, there's a lot there.
Sorry, I can pass the notes down if you need them.
If I forget something, somebody should wave their hand. With regard to, let's see, complaints-based kind of issues, every single district school building has to have a harassment-designated staff person to handle the complaints, and we monitor. We get the raw data of the complaints that have been filed and with the district, and then what action was taken. And, you know, and we have access to get the data that might be private under federal law because it's a law enforcement exception, if you will. So we do get a lot of data that will be coming in to the Department of Education as well as the Department of Justice. And we have designated people who will be looking at those reports. As far as enthusiasm for enforcement, well, the beauty of this is it's a federal court order that has to be complied with. It's not a settlement agreement, which is a contract and enforced by a contract. And I don't want to get too much into lawyer stuff, but this is a federal court order that we will be able to run back to the federal judge with if there's non-compliance. Now, you never want to go that far because it takes time. So to back this up are the very frequent periodic reports that the Department of Education and Justice receive. And we also, with regard to kind of the enthusiasm question, a number of the experts and consultants that that the school district has to hire they have to be blessed by the Department of Education and Justice. So we have highly trained, specialized consultants on the ground helping the district investigate the complaints, respond to harassment, identify the hot spots, work with the Gay Straight Alliance student groups. That's part of this as well. The anti-bullying surveys that have to be conducted. It's a lot of data coming in, but we have the consultants on the ground that are the ears and the eyes for us. And then we're here as well as in Washington and in Chicago looking at a lot of the data. So, I mean, you only can hope that all of these provisions and the fact that you have a federal court order, that there will be compliance and that it's 5 years. Most of the things will be starting to be implemented in the fall. We'll spend the summer working with the newly hired consultants, getting some of the revisions to their policies and procedures and complaints in place. One last thing, as far as other federal laws that have been mentioned and maybe activities by different groups coming into the school, a parent or a student who feels that they have been harassed as a result of some of these activities need to report. And remember, many of the students that we looked at, some of them were straight but had gay parents. Some hadn't come out yet, of course. It was early years in middle school. Others had come out. They all are covered under Title IX, which the courts have, and I don't want to spend too much time on this, identified that nonconformity to gender stereotypes in any way can be covered. So part of the system relies on reporting and complaints to be made, knowing that we're going to be looking at all that and how it's complied with.
Yeah, I just want to add, you know, our resources at Department of Education, Department of Justice are limited. We can't be on the ground 24 hours a day, 7 days a week. You are. You're seeing what's going on. And if you see that things are going on, call the local Office for Civil Rights, call the Department for Justice, let us know what's going on. The Office for Civil Rights at the U.S. Department of Education does enforce the Equal Access Act. You know, file a complaint, let us know what's going on, let us know your concerns. That is the mechanism by which we can know what's going on and help address it.
Great. So another question is, how are we including familial affiliation? So for kids who have LGBT parents, are there actual protections in regulation or law that protect them? If they're not, how are we addressing that population? I'll just add as a side note, you know, we were part of a research project with GLSEN and Collage a few years ago. You know, more than 40% of kids with LGBT parents are also getting harassed or bullied at school because of who their parents are. So it's not just LGBT youth, although clearly we are having a very heightened conversation about that crisis today. But so what's the protection for kids of LGBT parents?
Well, we have to remember that kids are bullied, harassed for a number of reasons. It could be that they are perceived as LGBT. They may be straight. I know when I was growing up, I was mercilessly bullied. I'm a straight ally. But when I was growing up, I was called a dyke. I was many other derogatory things that my 12-year-old self did not understand. But you know, there are many reasons that our kids are bullied, and it might not just be sexual orientation. It might be that they have, you know, gay parents. It might be completely unrelated to anything having to do with sexual orientation or gender identity. And that's why we have to make sure that the focus is on preventing bullying generally. In terms of federal protections, just as there are not specific federal protections in law at the moment for sexual orientation or gender identity, there's not really anything about you know, familial relations and that sort of angle. I think, you know, as these laws are considered, that's something else that needs to be considered and how that's actually going to be addressed. But at the moment, there's not.
One thing unique about the Anoka Hennepin's consent decree is that we also bootstrapped in the Minnesota Human Rights Act, which is, of course, much more broad than federal law. And that was because we had private plaintiffs suing under state law. And so this is one of the few provisions where you have federal enforcement by the Department of Education and Justice of the Human Rights Act, a state law that is much more broad. Now that doesn't, I mean, that covers a lot of things, and I'm not the state law expert by any means, but it does somewhat federalize some of the enforcement mechanisms, and so that we do have human rights provisions in this decree that will be enforced by a federal judge.
So this is kind of a bridge question, and one of mine, not one from the audience, but I think it sort of overlays both issues that we're talking about here. And we're seeing it in the work that we do at Family Equality Council, which is sort of the intersection of what's happening for LGBT youth and for families who are led by LGBT people with other targeted at-risk populations that oftentimes are experiencing some of the same sorts of situations or issues. So I was wondering if maybe you guys can talk a little bit about it in the schools context. For example, you know, there's bullying that happens around sexual orientation, gender identity, perceived affiliation, but clearly there's bullying that still happens around race, religion, and I think there's also this real question about, as we think about tough enforcement policies, what's the other impact that we're having on other populations that oftentimes are then being targeted as the people who are the bullies. I know I read recently that the victims of bullying are oftentimes the first people identified as being the problem, and so they end up getting swept up sometimes in the enforcement process. And I think, Brian, you know, from a family's perspective, you know, there's a lot of conversation about it. It's not just LGBT parents or LGBT youth, but you know, what from a policy perspective are we doing for single parents, for families that may be living on the edge of poverty? How are we accessing the services? So I was wondering if you could just talk philosophically about that a little bit and how we might address this a little more holistically than just with the lens of our own community.
Well, one thing I want to stress, zero tolerance policies are a misdirection. We know this. Everyone has a right to an education. It's not just your kid who may be getting bullied. The kids who are bullying also have a right to an education. And simply throwing them out of school or expelling them or suspending them isn't going to do anything. When they come back after a suspension, their behavior is not going to have changed. They have issues too. They have things that might be contributing to the reasons they are bullying others. So, you know, giving them services as well as those who are being victimized is very important. You know, we have to remember that these are all kids. These are all people who need to grow into adults, to live in a respectful community, to respect differences. These are the kids who are going to dictate future policy. And if you're not actually addressing the issue and simply kicking kids out of school, that's not going to work. You know, and the other thing is, we need to make sure that parents are informed of all of their rights and what the limitations are. One of the things that I always get questioned about is, well, why can't I know the punishment that the kid who bullied my kid got? Well, actually, there's federal law around this. The Family Education Rights Act, FERPA. I don't think I got that acronym correctly, but FERPA says that, his information is private. So the discipline they receive is not something that you can know. So I know parents are often frustrated when the schools say, trust us, we're taking care of it, but know that they're legally restricted from saying what exactly they're doing. And this is all stuff that we try to list out on stopbullying.gov, so you know what your rights are, so you know what to do and how to talk to the schools, and really what to do in those situations.
So just from a philosophical standpoint and from a pragmatic one, at least in the work that we're doing, we found it beneficial to actually push folks to think about this work as not really about equal access or equal treatment, but instead about equal outcomes. Because a lot of the youth that we're serving in child welfare or in the runaway and homeless youth population could be getting equally bad services, or services that meet the checkoff list for a service that's been provided, but one that can be incredibly inappropriate for what those young people need. And so we're really trying to push the discussion that goes on within our programs around equal outcomes. Because in that respect, what we say is we want all children who exit foster care to exit as fast as they can. And so you don't meet your obligation when you just try to get them all out, but that we actually want evidence that you did. And so that might mean that for different characteristics or populations, you may need to try different strategies to get to equal results. And so the shift that we're trying to make, it's a slow one, but the shift that we're trying to make is to get our programs to think about their obligation as providing the same kinds of outcomes, regardless of which strategy they use to get there. Because we think in the end, that's likely to turn into differentiated strategies to align with the needs and population in order to get to a different set of outcomes. So again, it's not a philosophical, lightning bolt or anything, but it's trying to shift one's understanding so that we're not just saying, give these kids the same thing that you gave those kids, but say, no, if we can get these results for some kids, we have an obligation to get the same results for other kids, regardless of what strategy it takes to get there.
And sort of a similarly veined question for all three of you. Whether it's the U.S. Attorney's Office or the Department of Education or ACF within Health and Human Services, you've all at some point had your agencies or organizations intervene at a local level around something important. So the Anoka Hennepin case, the LA grant is a great example of that. Can you talk about why you think that's significant beyond the local community that you're helping? What does it say to our country? What standard does it set for us, as a federal bar that we want to help people get to? And how important do you think that is?
Well, as some of you know, the Anoka Hennepin case engendered much publicity nationally. As the department was investigating this, there was a front page story in the New York Times about it, profiling particularly the number of suicides in the district. And it just snowballed into a lot of publicity throughout the litigation. The judge had a gag order on all of us, of course, but the media was swirling around. Now, having said that, this isn't, I think, an important decision or order, I should say, of the court, because it can set the bar for other cases. But of course, we don't have the resources to sue every school district, nor, frankly, would we want to. The key here is for people to go online and look at what's in this decree, which clearly was built upon other landmark decrees, Tehachapi out in California, the Mohawk decision in upstate New York. Both school districts are very small in those cases. This is the first one, as I mentioned, that's quite large. So we think that there's things you can pluck out, and school districts, administrators, school boards who are proactive can look at this stuff and say, oh, will this work at my school district? Will this work at my local level? And you just hope that you've just built upon things that have come in the past and that others coming forward will build upon this.
I echo exactly what he says. You know, our resources are very limited. We can't, you know, I'm speaking we as the Department of Education. I'm not in the Office for Civil Rights, so I can't speak to exactly what their processes are. But I know from what I've been told by my colleagues there, you know, their resources are very limited. They can't investigate every case or intervene in every case. They will go through and make sure that they have jurisdiction, et cetera, et cetera. But the fact is, one, they can't go into every school because they don't know about them. That, again, it's the reporting and in order for them to do compliance, but it's also the resources they have. And if they can point to, look, this is what happened in Anoka Hennepin, this is what your school needs to be doing because, you know, the same laws apply to your school as every other school in the nation. That helps. That sets a precedent that makes sure that schools know what their obligations are under the law. You know, our October 26, 2010 Dear Colleague letter from our Office for Civil Rights is an important document that outlines that a lot of schools try to circumvent harassment law by saying, oh, it's just bullying. You know, we're going to label it bullying. This is not our, you know, this is not really covered under those civil rights laws. It doesn't matter what a school labels it, it's still covered. So, you know, I think these cases set the important precedent, say, this is what happened in this school district. Does it parallel what's happening in your school district? If so, these are the steps you need to do.
Yeah. You know, it's hard for me to get much out ahead of the problem that's right around the corner for me. But I think ultimately, you know, our strategy has been that, you know, we haven't seen increases from Congress in additional resources. We haven't seen lots of attention paid on trying to make this issue, runaway and homeless youth or child welfare, bigger than it is. And so from my perspective, I think what we're trying to do is to say, most folks don't realize that when we give discretionary grants, at least in HHS, they're almost always 5-year grants. They're not 1-year grants. And so our hope is that we are taking the opportunity to make grant decisions and to allow there to be enough money set aside for rigorous evaluation so that the contribution that we're making today are trying the ideas that should drive the system tomorrow and giving people enough resources today to demonstrate over time that we can do something about this issue and that there are real benefits to it. And so I think to the extent to which there's a legacy or there's a future orientation, it is the hope that by making these large gifts like LA, it gives LA the 5 years and the resources they need to demonstrate that they can actually do something and they can produce a result that is important. And so the more examples of those we can get out there, the more of those 5-year grants we can make, the more rigorous we can be in our evaluation of that grant making, the greater is the likelihood that the next time somebody wants to address this issue, the issue isn't dismissed simply because nobody's done it before, right? That's usually the easy excuse. Well, you know, you say something and they say, you know, well, has anybody ever done that? How do you know that that'll work? You know, these grants provide the opportunity for evidence that when it's done, you can get a good result, and you at least eliminate the first line excuse for not addressing the needs of this community.
Great. So one last quick question for Deborah, and then I'm going to shift and Brian put you a little bit on the hot seat with some of these questions. But Deborah, if zero tolerance is a buzzword to be careful of when we're talking about school bullying and prevention, is there a better phrase to identify a more appropriate way of tackling the problem or the policy?
So I like to say no tolerance as opposed to zero tolerance. You know, zero tolerance came about very specifically in terms of, you know, if you bring a weapon to school, there's zero tolerance around that. That's the only place that there's actually a federal mandate that around zero tolerance. So that's a key word that's already built into sort of the nomenclature. I always like to say no tolerance, which is different than zero tolerance. No tolerance means that we will consistently address bullying behavior. Doesn't mean that we're going to kick kids out of school. It means we're going to address it, and we're going to do it consistently. So that's the term I use, but there are many other things, you know, that we are going to stop bullying, that we know that this is not normative behavior. All of these are important messages that we should send.
So Brian, Commissioner,
Yes.
we have a
Brian's
question.
fine. Yes,
Brian's
go for
fine.
it.
I'm used to titles. I like them. I think they're well earned.
Mine changes so often that I do better by just responding to the name I've been using for a while now.
Good you still like it then. So there were a couple questions about this, both in relation to kind of your keynote and in general what we've been talking about.
Yes.
So there's been lots of conversation about LG and B youth, but not a lot of conversation about T and the transgender youth that we have, and certainly in the sites that letter was missing from a lot of the research. So can you talk a little bit about, I mean, anecdotally, I think we all believe and think that there is an even higher risk increase for the trans population and among our young people, and why don't we have that information? What are we trying to do to get it? And is there something very specific programmatically that's happening with the ACF to address that community?
Sure. So if you use the literature as a basis to support any argument that you want to make, it's difficult, if not impossible, to find studies that have focused on the transgender population. So I'm a guy that likes to use data and literature to support my arguments. It's really difficult to find a good deal of information about transgendered youth in the runaway and homeless youth population or in the child welfare population. Where there is information, we have tried to use it and integrate it into the work that we're doing in two specific areas. One is really around the regulations for the runaway and homeless youth population, recognizing that whether you're in a transitional living program or using a runaway shelter, being transgendered represents an even greater challenge to using those programs to meet your needs. And so in the regulations, we're really focused on making the distinction between gay, lesbian, bisexual, and transgendered youth so that the programs don't treat them all equally and show a distinct strategy around the transgendered population. So that's one example of trying to move in that direction. And then secondly, and I think that this is an important one, and I would encourage you to talk a lot about this here in Minnesota, which is we also have, through both the funding that we make available to create runaway shelters, as well as the funding that we use to create transitional living shelters, we have highlighted the fact that there is enough room in the authorizing legislation to allow communities to make proposals to target specific populations. So most transitional living programs are set up to serve any youth who is chronically homeless and trying to move off of the streets into a positive adult trajectory. We have very few proposals that come in that say, of all of the kids who are transitioning from homelessness, we're going to target the gay, lesbian, bisexual, or transgendered youth. And so we're trying to encourage this community to really reach out to providers who are runaway and homeless youth, to make proposals that specifically address this population. And again, we highlight the transgendered population as representing a significant challenge around which folks could use this money and specifically address their needs. And so we can't make that one happen, but we can create an opportunity where we can begin to recognize the issues that are related to transgendered youth and begin to programmatically try to deal with them. And so those are two examples, but again, there's not a ton of literature. I'll make one other point, which is in the runaway and homeless youth population, there's no national data for anybody. So where we have data on the runaway and homeless youth population, it almost all comes from small studies done in limited areas or large studies where they've done it in multiple cities, but you can't extrapolate it for any national statistics. So we have little to nothing that we can say about the chronic youth who are homeless, and we're hoping that Congress will support providing funding so that we can do a national study to begin to identify the runaway and homeless youth population in a manner that we can design our programs to appropriately meet their needs. And obviously, knowing more about bisexual, transgender, gay, or other young people who are struggling, the more we know about them, the more we can make the argument that there are a unique set of needs to be addressed. And so hopefully, if we can get Congress's support for a national study on the runaway and homeless youth population, we'll be in a better position to argue for meeting the unique needs of the transgender population.
There is a national transgender survey
Yes.
on discrimination. It may not have all of the answers that you need around homeless youth, but it's the starting point. And it's the National Gay Lesbian Task Force and the National Center for Transgender Equality.
Yes.
And so I just bring that to your attention if you aren't on.
No, it's a great resource, and we have circulated it.
You talked a little bit about the guidance that ACF issued regarding recruitment of LGBT parents for foster and adoptive children. States receive federal funding for their foster care programs, and it's contingent right now on a number of things, but one of which is that states don't discriminate on the basis of race or color or national origin. So I was wondering if you could talk a little bit about you've clearly articulated in a very emphatic way that ACF believes people should recruit in the best interest of every child in the foster or adoptive system. We have the sort of federal guidelines about what you cannot discriminate on, and there's clearly a disconnect between what's happening on the states and their policies and what you ideally would like to see happening. So can you talk a little bit about how far can ACF go and what else needs to happen in order for you to be able to add sexual orientation and gender identity into that list of things that we don't discriminate around?
Sure. If you look at most, if not all, of the policies, at least in child welfare, there's no mention of gender or sexual orientation. And so we have to use non-discrimination in its broadest terms, and we rely on reports at the state and local level when it comes to knowing whether somebody is violating that non-discrimination requirement. But you also have to realize that, at least in the child welfare universe, the federal government makes up about half of the legal framework that drives child welfare. Every state makes the other half. So you're not operating one child welfare system in this country. We're operating at least 50. And in some states where the child welfare system is administered at the county level, like here, you're not just operating 50, you're operating however many counties you have in the state of Minnesota. And so the challenge around how do you hold states accountable for non-discrimination when no state is playing by the same rules in terms of how they're organized is certainly a challenge. So what we can do is to use the data that we have available to identify populations who aren't getting equal outcomes. So we try to do that. But again, because there's no federal requirement that states collect information about gay, lesbian, bisexual, or transgendered youth or questioning youth, we don't have a way of measuring explicitly whether a state is getting the same results. So we don't have much in the area of child welfare that we can manipulate in a way that allows us to say, absolutely, we're holding states accountable. So I'm using all the avenues that I have. And I can't suggest to you that I have more avenues than I do. And hopefully what we're also doing is demonstrating to states, with LA as a good example. Let me say one other thing. In child welfare, there's a misnomer that most of the money that runs it comes from the federal government. It doesn't, right? So if you look closely at any state in child welfare, only about 40% of the money comes from the federal government. The other 60% comes from state and county government. And so the states and counties actually have an interest in the system being smaller, right? Because every dollar they spend, 60 cents of it is theirs. And so states are driving towards getting smaller. What we're trying to do is to make sure that as they drive towards getting smaller, they have techniques for getting smaller for all kids and not just some kids, to get smaller for all families and not just some families. And so we're using LA and other examples so that we can give states examples of how they can serve this population better, because it's in their fiscal interest to do so.
So I want to just thank you, Brian. For those of you who don't know, Family Equality Council last fall issued a report in conjunction with the Center for American Progress called All Children Matter, and it was a report that focused on a wide variety of issues impacting LGBT families. And Brian was part of the launch of that report, did a big event at the Center for American Progress, and he spoke on a panel. And I just want to highlight that in addition to all the comments he has made about the foster care system, the ACF also administers a couple of key programs. Temporary aid to needy families and Head Start are two of them. And I think, we don't have time to go into every subject here today, but I think it's really important to note that we have such a strong leader in that department. And those are two programs that are really vital to our community. The reality is that LGBT parents are more likely, and their kids are more likely to be living in poverty or near poverty than heterosexual parents raising kids. And it's those programs that become very vital in a moment of need. And I think to have an advocate like we have in the commissioner who's thinking about and looking at how do we access those services as a community and thinking with us about the solutions to those problems is really great. So we weren't going to talk about it today, but I do want to thank you for that. And then this is really sort of the... This is a last question for all three of you, and then we're going to wrap up this portion of our program and we'll hear some closing remarks. But I think there is a really strong desire, and I certainly know it in the work that I do with all of you, that our families, and parents in particular, are really engaged and active citizens in making the world a better place for their kids and for youth all around them and for families all around them. And so, if there was one piece of advice or one sort of pearl of wisdom, since we're celebrating our 30th anniversary, I'm focused on pearls at Family Equality Council, what would you say to this audience who I know are so engaged in making the world a better place? What can they do to help you be as responsive and as proactive as you possibly can?
I guess I'll start. At the federal government, we're really limited in what we can do around bullying. We have our enforcement, which you've heard about under the federal civil rights laws, but there's not much else we can do other than give you guidance. Our role is to give the framework, the scaffolding, what have you, for people on the ground to do the work. But we can't be successful if the people on the ground aren't doing the work. So I really encourage you, again, StopBullying.gov has a lot of resources for you. Take that information, bring it to your schools, champion it. Make sure that everyone gets the message that bullying's not normative. If we all work together, we can make a difference here. but we're reliant on you to help us to do that.
Well, you know, Anoka Hennepin, the consent decree would not have happened but for gay parents, the parents of openly gay students, and every parent that was engaged in their students' lives and concerned about the suicide rates in Anoka Hennepin, coming forward, filing complaints. I mean, we cannot get involved unless there's a complaint. And the most powerful source is a complaint signed by a parent.
So this one is a stretch, but I'll put it out there a little bit and see how folks feel about it. You know, if I had one piece of advice, what I would say is that so much of the work that's being done right now for gay, lesbian, bisexual, transgendered youth is about solving a problem. And what the field really lacks is a vision and an understanding of what healthy development looks like in this community, and somebody out there articulating the positive frame of healthy development for all children who come to this community either because they're gay, lesbian, or bisexual, or they're being parented by someone who is. And so the community, I think, could take a huge step forward if it got really good at articulating the positive things you want to see in young people at each stage of their development, and to communicate to folks that the systems ought to be in place to promote those healthy developmental outcomes and not just defend against bad outcomes. So.
So I think you can agree with me that this has been a really amazing morning. We're going to have a few closing statements, but before we hear from Kevin Miller, the chair of our Midwest Advisory Council, and Mike Martinez, I just want to say thank you again, Greg Brooker, Brian Samuels, Deborah Temkin, for being here. I think this conversation is so timely. I think as we continue throughout the fall here in Minnesota, where the conversation about our community is going to be very heightened and at times can be very hurtful, really understanding in a much deeper way what is available to us to protect our young people is really critical. So thank you, and please, everybody, thank them again for me. And joining us on stage, please give a very nice warm welcome to Kevin Miller, who chairs our Midwest Advisory Council, and Mike Martinez.
Thank you so much. Thank you so much for being here today. This conference wouldn't be a success without you. I also want to thank our platinum sponsors as well, which is Target, California Cryobank, and Children's Tylenol. If you're staying for the Midwest Family Equality Conference, please do. Lunch will be served at noon. Please get your orange wristband if you haven't already. Our registration booth is right outside the door here. As you walk down, please visit the resource fair. We've got a lot of resource tables out there that are ready and willing to hear your questions and take any requests for information. The lunch will be actually at the end of the hallway on the right-hand side. Lunch is starting at noon, then goes to 1:15, and the first workshop starts at 1:30. If you're not registered, we'll sign you up here for free. Thankfully, we've had so many sponsors this year that we've made so much big effort to get a lot of companies' names on the program that we are now offering the afternoon conference for free. So thank you. Next is our closing statement from Mike Martinez. Mike is a special assistant at the U.S. Department of Agriculture. Thank you, Mike.
Thank you very much. Thank you, Kevin. As many people here in the room know, I'm a former resident of Brainerd and St. Paul, Minnesota. After finishing law school at Hamlin, I was appointed by the White House to serve at USDA, where I've spent the last 3 years in Washington, D.C. So I'm happy to be back home in the Twin Cities and see many of my friends and colleagues in the audience. And I'm pleased to be with all of you here today. I'm grateful that we were joined by Emily Hecht McGowan, Jennifer Chrysler, and other staff and volunteers at the Family Equality Council. But I have a special shout out for a few that have been really helpful today: Ella Robinson, Sean Carlson, Kevin Miller, and Heron Greensmith. So I have a question for everybody. The Family Equality Council, are they good or what? We thank all of the administration officials who joined us today to share information and resources and to highlight some of our efforts that are making a real difference for all families, including the Affordable Care Act, Assistance for Aging, safe schools for every student, and hospital visitation for all family members. Of course, we thank Senator Al Franken for joining us and for his efforts on behalf of every family. And thank you for attending. It has been a privilege to witness your Minnesota values and your family values. We are learning from your experience. All participants here in Minneapolis today will receive additional resources and updates from the White House in coming weeks. So we need your help to keep this conversation going, not just with those here today, but in your community, where you live, at your place of worship, on your blogs and on Twitter and on the internet. Thank you for your participation. Finally, I thank you for all of my colleagues, including today's panelists, Matt Nossencheck at Department of Justice, Gautam Raghavan from the White House, and I bring the best regards from President Obama himself. From all of us to all of you, thank you, and have a great afternoon.